Thanks, Senate Government Operations Committee, on February 18th, Thursday. And today we are going to look at what we hope is the final draft and potentially be able to mark it up and work on it, vote maybe, on the issue of juveniles and public records exemptions. So Tucker, do you want to just walk us through? And I see that Tyler is with us from DCF, but I don't see any of the other usual players. So I guess we'll wait and see when they appear. We did have this scheduled for 1:30, right, Gail?
Yeah.
Yeah.
I thought it was. I thought that's what it was.
That's what I thought too. So
Yes, Madam Chair.
We'll
Like
see.
that tie, Tucker.
All right, we have people coming in right now. We have David Scher and Marshall Paul.
Oh, good. Okay. And those are two of the people we've heard from anyway by email, but great. Tucker, walk through the thing, but tell Senator Polina about your bow tie.
The bow tie was a commemorative, let's say, gift from some representatives who appreciated me during my clerkship many moons ago. I guess it's almost exactly 24 moons ago.
Right.
So today I will walk you through the updates to your draft concerning public records and records related to the initial arrest and charge of persons under the age of 19. I will highlight each of the changes from the last draft and then do a high-level overview of the contents of the bill as a whole. And just while I was sitting here preparing for committee, I already have two technical corrections that we will have to update before the final version 2.1 is ready for you. So the first change that you will notice in section 1 is that the exemption has now been split off into its own individual subdivision, which will be 5B Romanet 2. The language in the first sentence is substantially the same as what you have seen in the past. It prohibits the disclosure of identifying information contained in a record reflecting the initial or arrest of the charge of a person under 19 years of age. Previously, it said of a juvenile. Based on the testimony you heard last week, this was changed to a years-based identification of the individual. And later on, I will highlight for you that there are two sections in this bill that will automatically replace that number with 20. So it will be 20 years of age, and that will take effect July 1st, 2022. The next sentence is entirely new. It states that a public agency may disclose identifying information relating to the initial arrest of a person under 19 in order to protect the health and safety of any person. This change was based on some requests from witnesses last week that specifically law enforcement agencies be able to publicize identifying information if there is a person who is at large and the public needs to know identifying information about that person. The next section under the new reader assistance heading labeled effective July 1st, 2022 will automatically update this exemption to apply to a person under 20 years of age when that age is raised in 2022. And this is the first place where we have a technical correction that needs to happen. The language in Romanet 2 doesn't match the previous section, and that was just a mix-up as we were proofreading. So that will be a quick fix later.
Can I just say, Gail, did you need to, you have your hand up.
Yes, we have a Kevin Gaffney in the waiting room. Is that a recognizable person?
Yes. Where is he?
Okay, I'm looking,
No,
I am
wait.
just looking him up, and it looks like he's Deputy Commissioner of Financial Regulation. Okay, thank you.
Okay, oh, that's where, yeah, okay, great, thanks. Okay, sorry, Tucker. And Tucker, I will once again comment on your use of the term Romanet. I love it.
I enjoy
I always
being
say
precise. So
Two little lines, but Romanet is much better.
So section 3 is still in here. It is still optional. The committee has not yet made the policy decision about this, but to cover it from a high level again, all new Public Records Act exemptions or any exemption that is substantively amended after July 1st, 2019 will automatically be reviewed for repeal every 5 years. So if you don't want this to come up for review in 2026, and then when it is amended in 2022 to be raised to the age 20 in 2027, you will have to add in this language to state that this is not subject to the 5-year repeal review. And this is similar to what you do with reports, where you state that it is not subject to, I think it's 2 VSA section 20D, to set it aside so that we don't review it under an automatic sunset.
Okay.
Section 4, most of the text is the same as you reviewed last time concerning court custodianship of all records relating to a person under jurisdiction of the family court. That is in subdivision 2 at the bottom of page 4. There is a new subdivision 3 on page 5, starting on line 3. And this language mirrors what you have done for a person who is under jurisdiction of the family court, but it relates to a person who is under the jurisdiction of the criminal division of the Superior Court. The issue that was raised last time was that the bill as previously drafted would have this odd scenario where a case that is referred to criminal court would be public, identifying information would be public. But because it wasn't under jurisdiction of the family court, the public agency under this bill would still be withholding identifying information, despite the fact that all of the records would be public once it goes to criminal court. So to resolve this and to not further complicate the disclosure of identifying information by the public agency, this subdivision says no matter which court it's going to, criminal court or family court, the courts will be the custodian of these records as soon as it goes to either court, and they will be responsible for releasing the information. If it's referred to family court, the information likely will not be released, but the court is going to be the custodian. If it's referred to criminal court, likely going to be public, but the criminal division is going to be responsible for responding to the Public Records Act requests. So to cover all of the temporal timelines that we're dealing with here, a little bit redundant, initial arrest happens. It relates to a person under 19 or 20, depending on the year it happens. The public agency may release records, but shall not release identifying information within it, up to the point that the case or that a charge is filed and it is referred to a court. At that time, the public agency stops being the responding public agency, and the court becomes responsible for responding to the Public Records Act request. That's the cutoff. If there is an instance where there is an initial arrest, but no charge is filed and it is not referred to court, the public agency will remain the custodian of the records, but shall not release identifying information contained within the records. And if it would be helpful, I can write all of that out so that you can see who is responsible for responding to requests and when. The last new section here, the effective dates have been updated. The entire act except section 2 takes effect July 1st, 2021. Section 2 takes effect July 1st, 2022. And that is the date that the age in the exemption will be raised from 19 to 20.
Perfect. Committee, are there any clarifying questions? Senator Collmore?
Thank you, Madam Chair. I think I heard you say this, Tucker, but I'm not sure. I think you said if a case is referred to family court, the identifying information likely will not be revealed. You used that word likely. Is that because potentially there would be a situation where one of those exemptions would kick in terms of public safety, or did you mean something else?
I used likely in an evasive way to protect myself from covering the court rules about records, which, as you'll recall from earlier discussions, are different than the Public Records Act. From what I understand from cursory review and from earlier testimony in committee from Pat Gable, the courts recognize the Public Records Act exemptions that are built in and that are specific around confidentiality. But I wasn't entirely certain about that. So I said it is likely that information will be confidential.
Okay, thank you.
Senator Polina, I think you had a question, and then Senator Clarkson.
Yeah, actually, it was a similar question, not only about the family court, but you also said if it went to criminal court, it would likely be disclosed, the information. So I thought it's very likely it'd be disclosed if it's criminal. It's just not clear on which it is. Is it likely, really likely? Almost definitely?
I would agree with your assessment that it is very likely.
Okay.
Senator Clarkson, did you have a question? Oh, okay, I'm sorry. Any other clarifying questions about this? And we'll hear get the testimony on it from different people, but thank you, Tucker. That was a really good review for us. And I know that Tucker has to run up to or down to Senate Education, around the corner to Senate Education. So he will be back with us when he's done there, or when he's quadruple scheduled. So he may or may not be back, but thank you. All right. So that's here we have, and I have heard from Marshall and from David Scher both, but I would like them to just talk to the committee about the bill as it is right now, the draft that we have right now. So Marshall, do you want to?
Sure. Thank you very much, Senator. And I will be very brief. We support the bill as it is right now. I think it covers exactly the bases that had been discussed in the last two hearings on this issue. And as far as, if I can just provide a little clarity around the sort of the lack of definite certitude, or, as far as what will be released when, there are always exceptions. So in criminal court, there is a general rule that applies 99.9% of the time, that everything that happens in criminal court is part of the public record. But there are very rare exceptions to that are handled on a case-by-case basis. That can be for things like, there's been cases where the government has been able to keep certain criminal court records confidential or sealed because releasing them to the public would release the name of a confidential informant. There's also sometimes that's done to protect sensitive witnesses or to protect witnesses that maybe haven't been disclosed in certain cases, but have been disclosed in others. And then in the juvenile court as well, there's a 99.9% of the time what takes place in the juvenile court is confidential. That confidentiality can be broken for various reasons. Again, like I said, 99.9% of the time, it won't be. And when it is broken, it's done again on a case-by-case basis for very specific purposes, which can include, I've done it as a attorney representing a kid in a confidential court proceeding, but where it's been felt that some explanation of the outcome of the case would be valuable not only to the state, but also to the defendant. The defendant can waive that confidentiality. So we've certainly done that in cases where it's been important and beneficial to everybody to have that confidentiality waived. So I think it's fair to say with 99.9% certainty that the records in criminal court are public and the records in juvenile court are confidential. But in both cases, there are those rare exceptions to that general rule.
Thank you. Any questions for Marshall? Thank you, Marshall.
Thank you.
And thanks for your definition and explanation of youthful offender the other day. That was helpful. Thank you. David?
Thank you, Senator. For the record, David Chair with the Attorney General's Office. I will also be brief. We support this bill as it is written. I think Attorney Anderson did a nice job of accounting for the various issues that have been brought up over the last couple of meetings, and we think this answers those issues and encompasses what we were hoping to see in the outcome. One other slight nuance I would add to the discussion is that it is important to remember that records can shift back and forth between, well, not back and forth, but they can be shifted. You know, a young person can be shifted from the jurisdiction of criminal court to juvenile court and vice versa if they meet, you know, given certain criteria around the offenses or around the age of the individual. And for that reason, I think it's another good policy outcome to have courts be the public records respondent. I think it eliminates a lot of confusion, gives one place that records requesters will go to, and the courts will know for certain where the youth is placed in terms of jurisdiction. So for all those reasons, I think this is nicely done and we support it.
Thank you. Thank you. Any questions for David? Okay. Let's hear from DFR. Did you want to weigh in again, Kevin? I know there you are. Michael Pichek was with us the other day, and I didn't know if you had anything further to add.
I don't have anything specific. For the record, Kevin Gaffney, Deputy Commissioner of Insurance at Department of Financial Regulation. Just a couple of points of, I think they've been clarified, but just further clarification. I know we've talked about motor vehicle convictions and DMV records, and I'm not going to assume, but I'm confirming that those records would still be accessible as they currently are, that any DMV convictions will find their way to DMV and be accessible by insurance carriers as they rely on that information for not only underwriting and accepting risks, but also for rating risks.
Once there's a conviction, yeah.
Yeah, once there's a conviction. So I think that's settled. The other record that I don't know if it was discussed previously is related to insurance, which is the accident reports that are done by either local law enforcement or whatever agencies at the scene. And certainly those records are, from a timeliness standpoint, even more critical. The DMV records, the adjudication process takes its course, and eventually, if there's a conviction, those find their way to the individual driver's record. An accident report is obviously something that's more timely, and someone may not be able to operate their vehicle. So the access to the accident reports is critical to the adjudication of claims and claim settlement. I think those would also, the accessibility of those would not change, but I don't want to assume that. I'm just raising that as, you know, now if something in the accident report is de-identified, it's still the facts of driver 1, driver 2 of the accident report will be available for claims adjudication. So those are the two areas that I just wanted to make sure that the bill wasn't intended to exempt from a public record.
Would those be after some kind of a conviction or immediately upon the accident?
Yeah, those are relatively immediate because, you know, you think about it, if you're sometimes accidents aren't clear in terms of fault, but sometimes they can be, you know, if you're rear-ended sitting at a stop sign, and you would certainly want to access that report as the person that was rear-ended to, usually you have the information of the other insurance company, so you can actually file a claim as a claimant against that other carrier.
I might be wrong here, and maybe David can correct me, but my understanding is that unless there's a charge of something like negligence or something like that, that the accident is, I don't know. David, can you help us out with that? I'm thinking that it doesn't cover them, but
Right. If I understand the question, and it's always possible I don't, but if I do, I believe the distinction here is that most of these traffic offenses, or I should say traffic offenses, period, are civil violations. And we're talking about offenses that are either charged or the subject of a petition, but are the basis for which is some sort of criminal activity.
Right.
Or something that meets the elements of an offense. So I believe all the things that you're talking about would not be encompassed by this change.
is that helpful?
That provides clarity for us. We just wanted to be sure that our takeaway was that.
Okay. Yes, Senator Colmer.
Thank you, Madam Chair. Actually, that muddies it up for me. I'm trying to think of an example. Two people get involved in an accident at a four-way stop. One of the operators is 17 years old. When law enforcement shows up, they take the information, they take the insurance information, they file a report. Is that report available to the media in terms of identifying who the operators were?
The way I look at this, and David helped me out here, is that there's been no charge. There's not an arrest.
No.
So that it would be public.
Okay.
Because they're not if they arrest the person because they were under the influence, or they arrest him because he was driving 190 miles an hour and caused the accident, then there's an arrest. And at that point, my understanding is then it would be not subject to public disclosure.
But if the local newspaper or radio or TV station was interested in reporting on the event itself, they would be able to say 16-year-old Jeanette White was involved in an accident with 48-year-old Ryan Scher.
If there wasn't an arrest.
Okay.
Is that right? Kevin, David, Marshall?
I agree with your assessment, Senator.
I agree also. I mean, the way that I read this, and I think it's pretty clear from the language, this just deals with arrest records, and that's what it's dealing with. And so if there's not an arrest, which there isn't in the case of the vast majority of traffic-related problems, then this has nothing to do with those cases.
Okay, thank you.
Okay, any more questions on that or for Kevin?
Well, I was distracted. Sorry, I was having trouble with my iPad, but those things that what we just talked about, the accident happening with the 16-year-old, that would become public though. Okay, that's I just wasn't sure I was hearing you right because I was dealing with my iPad problem.
Technology.
Yeah, really.
Yeah. Okay. So any more questions for Kevin or on that topic? I think we're clear on that.
Yeah, but I think it's pretty clear. Unless there's an arrest, this is not an issue.
Yeah.
Accident reports are public.
And speeding tickets and traffic violations are civil offenses, so they are public. All right. Tyler, thank you, Kevin.
Thank you. Bye now.
Kevin,
Tyler,
good
did
to
you
see you.
Same here.
Did you want to weigh in?
Sorry, Senator, were you asking me?
Yeah.
I just had a moment lapse on my computer here. Technology. Thank you so much. Good afternoon to the committee. Thank you for this invitation, I guess, last week, but also this week. For the record, Tyler Allen, DCF Family Services Division. I was asked to speak last week about this legislation's impact on licensing. And to this end, I shared the bill language, the prior bill language, previous to these revisions, with our residential and childcare licensing directors. I described the function, content, and intent of the bill as I best understood it. So DCF oversees licensing in a number of areas, including residential, foster care, after school, center-based, and family care homes. This licensure includes background check processes, which consider convictions, substantiations, and court findings, but also reviews family records known to the department. Like other testimony in the matter, DCF doesn't foresee any significant impact to licensing practices related to the passage of the bill. The practice of requesting records from a public agency without court jurisdiction isn't typical. And the likelihood that a pre-charge referral to a community justice center or court diversion program would be involving behaviors that would be barriers to licensure seem very small. But of course, DCF will continue to monitor the progress of the conversation, bring any illuminating concerns to the committee, should there be any.
Great. Thank you. Any questions for Tyler, DCF? Okay. So let's go to Sheriff Anderson. Did you want to weigh in at all? And specifically, does the section on with the addition of being able to release information if there's a public safety threat, does that meet your needs here? Is that sufficient?
Thank you, Madam Chair. For the record, Mark Anderson, Windham County Sheriff and Vermont Sheriff's Association. To be brief, like my predecessors, we support this bill as written. I'm trying to pull up the draft with regards to the public safety exemption because I have not seen it yet.
It should be on our committee page.
I just opened your committee page, so I'm there.
Okay.
I haven't read it yet, so I guess I'll remain silent on that until I can put some eyes on it. I do have one point of clarification based on a comment about tickets being public. The Vermont Civil Violation Complaint is a document that's designed by the Court Administrator's Office, and there's an indication, it's a checkbox that says a related criminal charge. Now, I think it would be appropriate that we redact the related criminal charge in the case of a juvenile case in which this exemption would apply. However, I would assume that a redaction would then imply that it was checked. So I guess I'm looking for clarity on how we are to handle referencing materials. I don't think it's by any means a game ender, just not sure how to deal with that.
So if you didn't make an arrest, but there's a box that you check that says there might be a related criminal charge. And if you check that, and then when you release the traffic information, the accident information, whatever it was, and that's redacted, the assumption is that it's been checked because maybe it should be redacted on every, I don't know.
And that could be a reasonable solution, is that we just always redact that field. I'm not sure if others might have a suggestion. Just wanted to
Yep.
make it a point of consideration. It's something that agencies, I think, will need to have in place depending on how this is enacted. But thank you.
So Thank you. Marshall or David, do you have any suggestion about how to do that?
Sure. I would just say that, I mean, that's a good thought. I hadn't thought of that issue. And now that Sheriff Anderson mentions it, of course, there is that box on the civil violation form. I think that form is prepared by the courts. And so perhaps the way to handle that would just be to direct the judiciary to make their form compliant with this new law.
Is that me that
Must be
went
on
away?
or anything. Oh, excuse me. Can you hear me?
I
Yeah,
think
you
you
just-
froze for a moment, but it might have been me.
Oh,
No, no.
okay. Yeah, I just got a pop-up that says my internet connection is unstable. So
Okay.
that's the danger of trying to do this from home. But so I think that it might be something where the judiciary can just revise their form to make it compliant, or where the form could simply be redacted in every case. So I think it might be something where there's a procedural rather than legislative fix.
Good. I like those. David?
I agree with that proposal. I don't think there's any need to try to deal with this in legislation. I think we can figure this out administratively.
Good.
And I
So-
am fine with those answers, Madam Chair, and having reviewed the public safety announcement exemption or portion of the under subsection 2, I'm comfortable with that language.
Okay. Anybody else have questions for Mark? Okay. So I see we have Mike here. I don't see, is Lisa with us? I don't see Lisa, but Mike, would you like to weigh in on this?
Thanks. She got called away at the last minute.
Okay,
And just the only point she was going to make, and again, it's Mike Donahue from the Vermont Press Association. I was trying to stay away from this because I've covered this story of Isabel
Right.
Seward, but I'm sort of, we're a small group, so I guess it's been punted back to me for just today. I think Lisa was going to essentially say the Press Association supports the status quo, much like the governor's office in DPS, and the tickets and citations continue to be public record, that there was just a small tweak that might be needed. It does seem there was some concern that the judiciary is going to control records of a separate branch of government, which is a little odd that the executive branch or legislative branch don't get to control their own records. I'm sure, I wonder if there'd be an uprising if the governor's office suddenly said they were going to control the legislative records, but I'll leave that debate for another day. I think we are happy that there is some possible relief. I think Senator Collmore brought it up a couple of meetings ago, sessions ago, hearings ago, about, you know, the guy that was involved in the shooting over at the University Mall, part of the Riverside gang that was in a shootout with another gang over there. They had 5 shots fired, and they've obviously put names out of at least one person that they want. So, I mean, I think it's critical that the police be able to turn to the public and say, we're looking for this person or that person. I mean, we just got a press release just in the last hour of 3 juveniles that are missing up in the Northeast Kingdom from a bunch of towns. Sorry, my apologies here. I forgot to shut my phone off. So obviously that becomes an issue for a lot of the police departments, state police and local police, to be able to get words out that there are suddenly these 3 teens from Hardwick, Barton, and Danville, I think it was, that are all suddenly missing up there. But all in all, we were glad to hear that the motor vehicle accidents will be fully available, that the traffic tickets, like the governor's legal counsel mentioned, since those are civil violations, that remains unchanged. So I think we do have some concerns that, again, somebody could kill somebody on the highway in Vermont. And as the editorial in the Times-Argus Rutland Herald said, it's $110 a body, and the person conceivably would never be identified. And I think that's troubling to a lot of people.
Thank you. I know your concern about, and Senator Collmore did bring it up, and I think that there was language put in here in response to his concern about the issue of public safety and being able to put someone's name out there if you know who you're looking for, and it's that person is a threat to public safety. So that language has been put in here, and I believe that would also cover the issue of the 3 missing teenagers, because it says for the safety, I don't have it right in front of me, but it is meant to cover those issues that either is a threat to public safety or the safety of the missing person or Senator Collmore, did you?
Yeah, I agree with you, Madam Chair, and Tucker's back with us. So I think the issue there is that the bill is silent on the safety of someone who's missing. Like, we have a skier down here in Rutland on occasion that'll, go off the path and get lost, and they can put the name of that person out because there's been no arrest, there's been no violation of law. It's just they're looking for him or her to try to find him. So I think, to Mike Donohue's point, the bill doesn't need to address that because there's been no arrest.
And in the case of the person that they're actually looking for, that they plan to arrest, there hasn't been an arrest yet either, but the language is in there to allow that person's name to be public. Is that true, Tucker?
Yes, the language is in there to cover what seems like a rare instance where there is an initial arrest, but the person is at large. And you would have to ask Commissioner Sherling about those situations, but he did say that there are instances where there is an arrest, but the person is not yet apprehended or in the custody of the public agency.
So, and I think yes, Mike.
Well, okay, I'm now totally confused because, and the sheriff, maybe if he's still on, I mean, there is no arrest really until a person is in custody, and basically, so I'm not sure what Tucker was saying there, because there may be an arrest warrant, maybe, but there is no arrest. So,
well, Tucker or Sheriff Anderson, do you want to respond to that?
Remember that the language of the subdivision states that records relating to the initial arrest of a person are exempt here, right? Persons under the age of 19. And there was testimony from law enforcement officials that there are instances where there are records relating to the initial arrest of a person that are created prior to that person being arrested. That is the understanding that I had from last week's testimony, and the reason that the ask was submitted for that clause allowing identifying information to be released from initial arrest or charge records in the event that that release is necessary to protect the health and safety of any person.
Senator Collmore?
Yeah, I think one example that we heard from, I don't know whether it was Sheriff Anderson or Commissioner Sherling, someone could have been arrested and taken into custody and then escaped. And that would allow the law enforcement community to put that name out there, because at that point, he or she is potentially threatening public safety. So you're correct, Mike, as far as it went, but there could be an example where someone's taken into custody, arrested, and then escapes, and that this would still allow that identity to be made known.
And I'm going to throw in another thought, and I think it covers this also because it relates to the initial arrest records. So if they know who's standing there at University Mall and is part, whatever it was that happened at University Mall, They know who it is. They're going to issue an arrest warrant. So there hasn't been an arrest yet, but there is a warrant out for the person, I would think. And this covers that situation also, where there hasn't actually been an arrest, but they're looking for a particular person. Am I right about that? Tucker, Sheriff Anderson, Marshall. Everybody's on mute.
I mean, I think you're pretty clearly correct about that, because that, you know, it is a record that relates to an arrest, but there is a public safety issue.
Right.
So while it falls within section 1, you know, the public safety issue makes it so that it is exempt from the prohibition and can be made public. And it's, just to be clear, it was me who said that I'm aware of cases where I've had clients who have been arrested and then escaped, and there's been a need to find them. And that's, you know, I would say it's not even necessarily, you know, certainly if someone has been arrested, then this law might apply to them. But then, of course, the public safety exception would allow disclosure for public safety, or, and this is the point I wanted to make, was sometimes it's not public safety, sometimes it's for the safety of the kid. In fact, I would say most of the time when I've had clients who have escaped, there's been a lot of worry. It hasn't actually been worry for the safety of the public, because most of our clients are really not threats to the public. But there's often worry about the safety to that kid. And that was part of what I was really happy to see in this bill, was that it allowed disclosure, not just for public safety, but for to protect the safety of any person, which would include the kid themselves.
Good. Yeah, I think that you are right about that. Senator Clarkson?
Yes, I'm just concerned by the word, the warrant, the search warrant.
Not search warrant. I didn't say search warrant.
No, but to go back to what I thought I heard Mike say, and I think Mark, I mean, when you're searching for someone, you have to put out a search warrant, right?
No, that's not a search warrant.
Okay, it's just that, okay, because that was my concern, is with a search warrant, don't you have to identify a reason for that? And might be awkward.
That's not a search warrant.
Okay, what is it called?
Arrest
I think
warrant.
it's an arrest warrant. You're looking for them to arrest somebody. It's an arrest warrant, not a search warrant.
Okay.
There's a difference between searching for somebody and searching a house or a car. That's a search warrant.
Okay. I'm sorry, I'm confused. So we're exempting the arrest warrant?
No. Oh, if here's,
I thought, I mean, if it's called an arrest warrant, I have a concern, because anyway, I guess
if it's in the public safety, if they know who the person is,
right,
and the person presents a risk to either themselves or to somebody else or to the public,
right,
then they have the ability to disclose the name.
Right. Okay. Got it. Thank you. But it's called an arrest warrant. Yeah, that's disturbing, but yeah.
Well, that's what it is. It puts out a warrant for your arrest.
Yeah.
So anyway,
just to add a point that might be more confusing than clarifying, but in the juvenile world, we don't usually have arrest warrants. We usually have juvenile pickup orders.
Okay.
They essentially are the same thing, but a little different.
I think that the less technical jargon we use in this instance, the better off we are, just knowing what it is we're trying to do here. We're trying to keep arrest records of juveniles confidential, because they might end up going to family court where they're confidential, and then that confidentiality is a little bit irrelevant since it's already been made public. But we are exempting from this prohibition of the release of information anything that would the name of anybody who would either pose where they're looking for someone who would either pose a risk to themselves or to others. And that in that case, those names could be those names or that an identifying characteristics. It may not be their name. It may be the identifying characteristic. It's a blonde 16-year-old woman from Putney. We're not sure what her name is, but it's identifying characteristics. Okay. Are we clear about this now? Yes, Mike.
I just want to, Senator Clarkson, just to be clear, a judge does in fact sign an arrest warrant. It's just not handled by anybody, but the police have to go and get an arrest warrant from a judge usually for an adult pickup. And I just want to be clear on one thing. So in the situation with the Riverside gang at the University Mall, the person who's wanted primarily there is 18. It's an adult arrest warrant. But just to be clear, the state's attorney can later decide that they want that case to go to family court, but the name is still was out there at some point.
But in that case, it would fall under the exemption for the public safety.
Right.
Yeah. But I just wanted to make clear that you may have a situation where it's public at one point and then suddenly it becomes confidential, but everybody knows who it was.
Right. Well, I think Marshall was right in his assessment that 99.9% is about as close as we can get to anything.
But I thought it would be clear, Madam Chair, that anyone who was 18 was still considered a juvenile, no matter where you were in the pickup process. That until you were convicted, if no matter what happened, other than the search thing, other than the search warrant, the anything that happened other than a civil offense, if anything else, 19 or under was considered a juvenile. So Mike's example, the 18-year-old shouldn't happen.
Unless the proactive disclosure is necessary to protect the health and safety of any person.
Yes.
And in the case that Mr. Donahue highlighted, the public agency would be permitted to release that information in order to protect the safety of a person and would do so, but later may not be permitted to release that information in a record reflecting the initial arrest, which was Mr. Donahue's point that you may have redactions later, despite the fact that the identifying information has already been released and the public is aware of who the person is.
Right. Imperfect, but there we are. Right.
Well, our systems are all somewhat imperfect,
right.
And it is impossible to craft laws that cover every situation. But I think that the intent here our move is to in justice reinvestment and justice reform is to for the protection of people so that their lives aren't ruined. And I understand that there is public interest in lots of stuff, but we need to be able to weigh the individual rights with the public's right to know. And sometimes the public's right to know is, I hate to say this, but just to be just because they want to know, it doesn't serve any purpose necessarily. People just would like to know who that kid was that was arrested. But anyway, so anything else that anybody would like to say here, or are we at a point where we feel comfortable with this? Senator Clarkson?
Yes, that was a.
Oh, okay. I couldn't tell.
I'm fine.
Keisha?
Yep, I think we're good to go.
Senator Polina?
Yep.
So can we make this a committee bill?
I thought it was.
Well, it isn't anything yet.
Oh, it's still just draft number, right?
I'm
Yes,
still
let's,
planning on voting no on this, Madam Chair.
So then I think we won't make it a committee bill. I mean, it can't be a committee bill unless we all agree.
Right.
So,
so
Tucker,
let's make,
yes,
so then we're gonna make it a bill of Clarkson, Rom, Polina White.
if that's what, if everybody wants to be on there except Senator Collmore, that's what I would suggest.
Great.
Okay. All right. So Tucker, can we do that? And I don't.
Yes, I will get that started.
Okay, and then, so it can, this doesn't have to go to any other committee. It won't have to go to appropriations or finance or anyplace else. And I've been keeping judiciary involved in the conversations. So even though they're not really involved in law enforcement. Okay. Thank you. Thank you. All right. So can we move on to our municipal pilot bill? And is that you again, Tucker?
It is. Are you all tired of seeing me yet?
Wait, Mike, did you have a question or were you waving goodbye? You're muted, so I can't tell what you're saying, but I think you're
Oh.
waving goodbye.
I'm waving goodbye. Thank you for your time on this and everything else.
Thank
Thanks,
you.
Mike.
Thanks, everyone. Yep.
And I see Gail has her hand up.
Yes, Madam Chair, Karen Horn and Gwen Zakov will be joining us at 2:30.
Oh, I thought it was 2:30. Okay.
We're close. We've got about 6 minutes.
Oh, okay. Well, I think we can start walking through it.
Okay.
Thanks. All right.
Shall I start, Madam Chair?
Yeah, can I, I was looking at before you start, I was looking at some stuff the other day. It was in our Title VII. I don't remember where it was, maybe in the Constitution. Anyway, it's interesting because the way the federal Constitution and the federal statutes work is that the states can pass and can regulate anything that isn't prohibited by the federal government. So we like that as a state, but yet we impose the exact opposite on our own next level of government. I just thought I'd point that out.
Madam Chair, I took a class called Local Government Law at Harvard Law School when I was a grad student at the School of Government. And it's a class the teacher's been teaching for 40 years. And it's essentially about that topic and why that works. So if you ever want to borrow my book, it's a whole exploration of that topic.
No, I mean, isn't it Article 10 of the Constitution that
It is
says
the
that?
10th Amendment.
10th
Yes.
Amendment.
That
Mhm.
any powers not granted to the federal government are reserved to the states and the people. It is the only amendment that grants rights and powers to a unit of government and not to individuals specifically.
And yet we don't grant the same power to our next level of legislative bodies or government. So anyway, I just thought I'd point that out.
This is one of her favorite subjects, Keisha, in case you hadn't noticed.
Well, I've taken that class. Barack Obama's taken that class. Moreau Weinberg has taken that class. I highly recommend you go take that class. It's really
I've taken it from Frank Bryan.
nice. And I
And
took
many
the class as well.
many tutorials from him.
Yeah.
So, okay. Sorry about that. I just had to throw that in as always.
It's a good place to start.
Yeah, someday maybe we can have the summary, what did we call it? The little yellow books, the
Cliff notes.
The cliff notes on the class would be very helpful. But given none of us, at least not at this point, are going to the Kennedy School.
All right, Tucker.
Well, the Supremacy of Laws is a great place to start, and it does play a role in this bill. And an important thing to note about the way that the Dillon's rule states operate in comparison to any other model of organization of local units of government is that the General Assembly in the state of Vermont can grant any specific power, delegate any specific legislative power that it sees fit to any municipality within the state, which is unique and potentially very powerful for units of local government if you grant them the power. The bill that you have in front of you is a rerun of S-106 as it came through this committee and was passed by the Senate last biennium. There is one clarifying edit that was made for purposes of the draft you have in front of you. It's highlighted in the document as it was posted, and I'll cover it when we get to that point. It's the only change made from the bill as it passed out of the Senate last biennium. The bill starts with a findings and intent section that describes findings of the General Assembly concerning the relationship between municipalities and the state. It begins by stating that the General Assembly finds that state law and policies at times inhibit or delay the ability of municipalities to adopt and implement solutions to local problems. That state law, policies, and procedures limit the ability of cities and towns to creatively work with the state in a timely and efficient manner. That municipalities lack the ability to make the best decisions to meet their truly local needs. And that establishing the pilot program authorizes a limited number of municipalities to engage in self-governance within defined parameters, and that will allow the state to determine gaps in municipal power. It will provide a laboratory for cities and towns to develop local solutions, and it will allow municipalities within the program to more efficiently respond to the needs of their residents. Moving on from the findings and intent, we'll get into the operative provisions of the bill. Section 5802 is added to define certain terms for use within this new chapter and to cover the general eligibility of applicants to the program. This section defines commission, municipality, program. Municipality is the one that you'll want to take a particular look at. The definition of municipality is limited to incorporated cities and towns. No other form of municipal corporation in the state would be eligible to participate in the program under this chapter. Proposal is defined here, and this limits some of the eligibility as a plan that describes the enumerated powers that the municipality requires for the adoption of ordinances that are not in conflict with the U.S. Constitution, the Vermont Constitution, federal laws, and the state laws that are listed in section 5805 sub C, which we will get to later. It's a long list, and that provide for the health, safety, and welfare of the population within the territorial limits of the municipality. This is another piece that gets repeated and hammered on over and over again in the bill. This is limited to the authority that the municipal corporation has within its territorial limits, and later it's expressly stated that any of the ordinances or powers that are granted won't allow a program participant to affect any other municipality. Further, that the plan describes the measures a municipality expects to pursue, including the adoption of any ordinances. Section 5803 contains the procedure for adopting a proposal that will be submitted to the commission and later to the General Assembly. And this procedure is modeled after the charter amendment procedure that exists in Title 17. And I'll move through this somewhat quickly. If there are any particular questions about the process, happy to get into it. And I believe that this section was the first time in my career as a legislative counsel that I used the blackboard in the Senate Government Operations Room, because we mapped out how long it would take to adopt a proposal. So a municipality that is seeking to participate in the program is going to be required to submit their proposal to the voters and follow the following procedure. First, that an official copy of the proposal shall be filed with the clerk. 10 days before the first public hearing. There are two. The legislative body shall hold at least 2 public hearings before the vote at an annual or special meeting. The first public hearing shall be held at least 20 days before the annual or special meeting. The legislative body has the authority to revise the proposal in light of recommendations made at a public hearing, but that no revisions may be made fewer than 10 days before the vote. The second public hearing shall be held not later than 10 days after the first public hearing, so you have 2 in somewhat rapid succession. After the warning and hearing requirements are satisfied, the proposal is submitted to the voters at an annual or special meeting in its certified form, and the legislative body has permission to make technical corrections prior to that point. Municipalities are permitted to amend an approved proposal after it's been approved by the voters by following the same process we just went through. It's the same as charter amendments. You still have to follow the charter amendment procedure. Upon approval by the voters, the legislative body shall submit the proposal or amendment to the commission. And that segues beautifully into Section 5804, which creates the Municipal Self-Governance Commission. The commission is created and consists of 12 members who are appointed as follows. First, 4 members shall be appointed by the governor, not more than 2 of whom shall be from the same political party. 8 members will be appointed by the General Assembly, 4 by the Senate Committee on Committees, and 4 by the Speaker of the House. Of the members appointed by the Senate, not more than 1 may be a legislator, and not more than 2 may be from the same political party. And of the members appointed by the Speaker, not more than 1 may be a legislator, and not more than 2 may be from the same political party. The terms of members of the commission are 2 years. The commission shall have the power to review, evaluate, and make recommendations concerning a proposal submitted by a municipality. They'll have the authority to establish criteria for the evaluation of proposals, and that includes each municipality's population, geographic location, and governance structure. They will have authority to consult with state agencies that may be affected by the proposal, and to recommend to the General Assembly the municipalities that should be approved to participate in the program. Subsection E states that the Office of Legislative Counsel will provide administrative and legal assistance to the commission. The commission shall have its first meeting at the call of the Speaker of the House, and that shall occur on or before November 1st, 2021. The commission shall elect a chair from among its members. 8 of the 12 members are required to constitute a quorum of the commission. Subsection G covers the compensation and reimbursement of the members of the commission. G1 covers legislative members, and that per diem compensation is governed by 2 VSA section 406. All other members their compensation is governed by 32 VSA section 1010, which is the section that governs all other members of commissions that you've probably reviewed many, many times, especially if you were on the Boards and Commissions Review Committee. Payments will be made from monies appropriated to the General Assembly. Subsection H deals with required reports. So first, on or before January 15th, 2022, the commission shall submit a report recommending at least 1, but not more than 10 municipalities to participate in the program. And the commission is required to recommend municipalities that represent a range of populations, geographic locations, and governance structures. At any time after January 15th, 2022, the commission can submit subsequent reports recommending additional municipalities but at no time during the existence of the program shall more than 10 municipalities be admitted to participate in the program. I will note that, of course, statute would not bind the General Assembly's authority to admit more than 10 municipalities if that's how the General Assembly decided to proceed. On or before January 15th, 2026, the Commission is required to conduct a performance review of the program and submit a report that contains evaluations of the effectiveness of expanded self-governance, a recommendation as to whether the program should be reduced, expanded, or terminated, and a recommendation as to whether additional legislation is necessary to modify the program, including any recommended additions to Section 5805 sub C, which is the list of prohibited statutes that the proposals cannot touch, and any other relevant matters. Commencing on January 15th of the year 2023, and each year thereafter, the Commission is required to submit a report that contains all of the municipal progress reports, which we haven't gotten to yet, that are required by Section 5805 of the chapter. So they'll be bundling all of these municipal progress reports and submitting them to the General Assembly. The Commission is required to hold program meetings with the attendance of representatives from each of the admitted municipalities participating in the program. Legislative bodies of each participating municipality are required to appoint a representative who attends these meetings. And that is all for that Section 5804. Section 5805, this is the critical operative piece of the bill, and where last biennium there was the most tension and confusion about how the program operates. It's also the only place where there is a clarifying change or edit from what you reviewed last biennium. Subsection A states that, consistent with Chapter 2, Sections 6 and 69 of the Vermont Constitution, the General Assembly shall have the sole authority to approve proposals and any proposal amendments and admit municipalities for participation in the program. So the new language is the addition of shall have the sole authority. It is redundant. As it was written last year, it stated that the General Assembly shall approve proposals and proposal amendments. It was written to reserve all authority to admit the municipalities to adopt statute, which is an exclusive power of the General Assembly. But this was added to make certain that those who are reading the bill understand that the General Assembly has the final say in all of this. A municipality that is approved by the Assembly for participation in the program will have authority to adopt or amend ordinances pursuant to the powers that are granted to them. And now in subsection C, we get to the list that sets aside what a proposal may not touch. So subsection C states that a municipality's proposal shall not include the authority to adopt or amend an ordinance that is inconsistent or in conflict with the US or Vermont Constitution, federal law, the Public Records Act, the Open Meeting Law, what is colloquially described as the Sportsman's Bill of Rights. That's 10 VSA section 5227, 24 VSA section 2291 sub 8, and section 2295. And to refresh your recollection, those sections deal with the regulation of sport shooting ranges, and regulation of hunting, fishing, and trapping at the municipal level. There are prohibitions. I would recommend going into those statutes if you're curious about what is being restricted here. State law governing the following subject areas are also set aside from the proposals here. Firearms, the environment, conservation and development, forestry, or fish and wildlife. And in that sub B, those terms were specifically selected because they relate to entire titles of the Vermont statutes annotated that were lifted from the program. Crimes and criminal procedure, cannabis, state lottery and games of chance, alcoholic beverages, except that municipalities here may propose to increase local license fees, health insurance, banking, securities and insurance, electric utilities, workers' compensation, minimum wage benefits and employment protections, elections except for local elections, state highways, state sign law requirements of 10 VSA Chapter 21, standards for classifying town highways under 19 VSA Section 302. I know that well. I live on a Class 4 road. Procedures for laying out, discontinuing, and reclassifying town highways under 19 VSA Chapter 27. Motor vehicle requirements of Title 23, except for Chapter 19 of Title 23, which relates to parking, aviation, or railroads. All of those are pulled out and may not be contained in a proposal. Subsection D states that a municipality shall only have the power to adopt an ordinance or bylaw that applies within the territorial limits of the municipality. They cannot adopt an ordinance or exercise a power that would require or prohibit action by any other municipal corporation. And to help you understand some of the discussion that happened around this particular subsection, this was about whether municipalities would be given authority over school districts. School districts as an independent municipality called out here, the municipalities would not be able to exercise that authority. Commencing on October 1st, 2022, and each year thereafter, the participating municipalities shall submit progress reports to the commission. And if you recall, the commission will start bundling those annual progress reports and send them to House and Senate government operations. Those progress reports shall contain the following minimum requirements: a narrative description of how the authority granted to the municipality has been exercised and what the results have been, a list of the ordinances that have been adopted pursuant to an approved proposal, the estimated fiscal impact of any ordinance that has been adopted, and a summary of any pending or active suits, proceedings, or petitions that challenge those ordinances. And finally, any information that the commission may require for purposes of exercising their duties under this chapter. Section 5806 provides that the program shall terminate on July 1st, 2026. So it's only going to be in existence unless the General Assembly comes back and amends this for 5 years. Any ordinance that is adopted during that 5-year period that the program exists and is approving proposals will continue to be in full force and effect until it is either superseded or repealed. No ordinances may be enacted by a municipality after the termination of the program. The effective date is on passage.
Yay. So are there any technical questions for Tucker? I have a couple comments, but Senator Collmore and then Senator Clarkson.
Thank you, Madam Chair. I think I've figured out the answer but let's see. Page 5 is where the creation of the Self-Governance Commission is talked about. I'm assuming that since the Committee on Committees and the Speaker are responsible for 8 of the appointees, they have to be from the General Assembly. In other words, could they appoint Joe Public?
They have to.
Yeah.
Okay.
Only one can be a legislator.
All right. And my second question, in the list of prohibited areas of government, education is not listed, but I think you sort of answered. In other words, if a municipality said to itself, hey, you know what? We think everybody that only goes to 10 grades should be able to be a graduate of high school. That wouldn't fly because the other municipality, the school district, comes under the Agency of Education jurisdiction, correct? And bless you, Madam Chair.
I'm actually not sure how the relationship would work. If the school district controls those educational requirements, which again, I'm not certain that if they do, then the municipality would not be granted any authority under this program to control the school district's area of authority. However, something that I brought up even when this exhaustive list was being put together, this list communicates to each of the municipalities applying to the program what the General Assembly does not want to see in a proposal, but it does not restrain the General Assembly from granting whatever authority they choose to give at a future date. So,
I mean, that was an extreme example, but you know, a town or a city, I guess, could decide what topics to teach in their own schools. But I still think they're under the aegis of the Agency of Education. I don't think they can independently decide that. So I think that word education does not necessarily have to be in the list. And these are municipalities that only are cities or towns. Are there any GORs that, I mean, I know you're a GOR expert, so I didn't know whether they would be part of this or not.
no, the definition calls out incorporated cities and towns. So the GORs
Right.
would not be included,
Thank you.
nor the grants.
Senator
Well,
Clark.
Senator Rom. Oh, Senator Clarkson first, and then Senator Rom.
thank you. I had a couple of comments. A technical one, you said that the commission shall elect a chair, and yet the word you have on page, on page 6, line 11 is select a chair. I like the idea of selecting a chair. But anyway, that's just a technical, you asked for technical things. I agree with Brian. I had education as one of the questions on the list, and also revenues. The revenues of the state are a big issue, and it is having served on Ways and Means, we do not grant municipalities the opportunity to raise revenues of the state. I mean, in very specific situations, we grant them the opportunity to have a local option tax, and that's it, other than fees.
So I'm going to go to Senator Rom first, and then, because then we'll get into these discussions, because I think that goes just beyond, a little bit beyond just a technical clarification here.
Oh, I'm sorry. Okay.
I just wanted,
I had those on the list. I had those two concerns: where are revenues and education.
Yeah. But I just, so Senator Rom, did you have a clarification question for
I think
Tucker?
it's a clarifying question. I was wondering if this applies to uniform codes, like streamlined agreements we have with other states, interstate agreements with places like New York or Massachusetts or New Hampshire, or international agreements we have with Lake Champlain. What if someone, yeah, I'll leave it there.
There's no prohibition here from a proposal from a municipality that might deal with one of those subjects and that is not already prohibited by the exhaustive list in subsection C. But recall again that whatever proposals come in are reviewed first by the commission, and then the commission selects the proposals that get advanced to the General Assembly. And then you all get to have a substantive debate about whether to approve the proposals and admit municipalities. And because that is within your supreme legislative power, you have the red pen to strike out anything that might interfere with, for example, an interstate compact or the state's required participation in any of those compacts or agreements.
Okay. I'm not even saying I disagree, but what if one town on the border wanted to like do something with Canada, and they get it really creative? Or what if it was like a Lake Champlain related issue? How would other jurisdictions then know who rules are like
we
feels
would approve.
complicated.
Yeah, and in
So
addition,
they have
there's
to come with their
Yeah.
package of changes. That's kind of like a charter change, isn't it?
Well, it is, except
Okay.
that it is, except that it's anyway. I'm sorry that we have to go through this horrible, protracted process to give the towns any authority at all to make any decisions.
I hear you.
But just given the nature of the General Assembly, this is what we have to do. And I have to say, I think this, I have two things here. One technical thing is they can't even put stop signs on their town roads, on the town roads. That is ludicrous. But anyway, I have a huge problem with this humongous set of things that they're not allowed to do, because I think that that's, but people got all upset about it. And then the other thing I would do is I would drop the findings. As I remember, the findings caused a lot of consternation on the floor. People said, what do you mean the state laws prevent them from being creative? And as I remember, there was a lot of conversation about the findings itself, as opposed to the concept of allowing more self-governance. So I would just completely drop the findings. So, Senator Clarkson?
I'm not sure. I mean, I can see streamlining them, but I think it's very important to clarify why we're doing this and provide intent for people to understand, because I think most people don't have a clue about the restrictions at the moment that municipalities face in making decisions and in doing things on their own. I don't think they have a clue. So I think that actually, even for the General Assembly, I agree. Perhaps we would not want to do anything that begs more questions, but I think we should be very clear on our intent with what we're trying to accomplish in this bill.
I agree, but I think intent is different than findings. And we can put an intent in there without having all of those findings that talk about how we don't allow them to do anything and how it curbs their creativity. And that brought on a lot of discussion last year,
Right.
as I remember. And I think it's our responsibility to let the General Assembly know. Anyway, we can leave them in there if we want, but we definitely should streamline them and make them not controversial isn't the word I'm looking for, but a lightning. Sometimes, as Peg Flory used to say, she had seen bills actually die because of fights over the findings as opposed to the content of the bill itself. So, and I've seen that too. Senator Collmore?
I agree with you, Madam Chair. I think there are 4 findings. The first 2 are negative, and I don't see any need to be negative. It says that, we inhibit or delay the ability and we limit the ability. And I would like to see a phrase like, it will allow the municipalities to be nimble in terms of trying to figure out on their own how to solve problems which only affect them.
Yes.
I think if you turn it and you're positive, people will read it and say, "Oh yeah, that sounds good."
I think that's an excellent point. They all need to be flipped, and it needs to be more intent-driven. Clarify what our objective is with it, and make it positive. This is what it enables. Yeah, good. I absolutely agree. That's part of the problem I think Jeanette's having with the findings.
Senator Collmore and then Senator Rahm. Paulina,
Okay, we spend a lot of time together, so it's easy to confuse us.
And you're right on top of each other right now on my screen.
I'm going to ask sort of a rhetorical question. I obviously support this. I supported it last year. I support it this year. But I must admit, revisiting that list of all the things you can't do makes me wonder, and maybe I'll ask Gwen or Karen, I mean, what else is there left to do? I mean, if you don't have an answer, that's okay, but it's just sort of bothering me that like we've limited it so much. I mean,
Yeah, I think it bothers us too, but it became, the way I described it, it became a bit of a Christmas tree where we were decorating with all the different ornaments of interested parties that were concerned about their own individual needs. And I think what everyone was missing in the larger conversation is that there is no exhaustive list like this that exists for charters. They can do all these things in charters. That doesn't mean it's going to get approved by the legislature. You're just artificially taking up a whole bunch of things preemptively. And so I think that's our biggest problem with it, is that there wasn't that, I don't think that message was conveyed, that, you know, not only are we going through the charter process, we're actually adding an extra layer onto the process. And then on top of that, we're adding a list of things you can't do. So it's definitely like a neutered version of what we would want. But I think it got lost in the messaging. So this looks very different from what we had proposed initially. And it's definitely not ideal. And I would agree that, you know, the idea of this is to basically create sort of a living charter, because right now the biggest problem is that, you know, you have things that are written in law, whether it's general statutory law or a charter, that never get revisited. No one sees how they work. No one figures out if there are barriers to break down and kind of work things together, whether, you know, functions can work better between even just like committees that are established in a town, something really simple like that, like a cemetery committee or a library, whatever. I mean, it could be anything. And so this would be an idea to just get it rolling. And then if it's successful, then building off of that and seeing, wait a second, if we're not so prescriptive in general law or charter law, and it's, the world didn't fall apart, maybe it's not so bad to just hand the reins over to truly local things. So we share your concerns.
yeah, I didn't bring that up to derail things. It just was bothering me. So
I would cross them all off if it were up to me. Senator Rahm?
I think I'm more in that direction too. I was just curious historically in the committee, if there was a conversation, instead of saying what you can't do, being clear about the areas where you can, and which I think are where it doesn't conflict with state or federal law, or maybe some, I might add like some kind of interstate compacts and international agreements. But, you know, everything I can think of that communities have wanted to do is somewhere on this list, you know, that seemed like the experimental way to give towns the ability to be laboratories of, you know, so I would say, I would just limit what they can't do, or say in these broad categories, this is where you can experiment.
Can I just say something there?
Yeah.
I think that we explored that, and I don't know if what happened in committee or out of committee, but you kind of get to the same result, because you say, oh, we want to deal with local issues. And then you say, well, what does that really mean? You're like, well, you know, it could be zoning, it could be roads. And then when you bring in that, and you're like, well, you can't touch this regional aspect of things, or you can't touch the state roads. And then, you're still, even when you bring up a topic, for example, like, you know, oh, just like liquor license fees that have been set in statute forever and no one's changing. And then they're like, well, we don't want you to do anything else other than that. So we have really specific carve out. So I think we wanted to do it that way. It makes way more sense to do it that way, but it still kind of got to the same result, you know, like you were still adding things to the list.
Well, I think what happened is that it started out, and I would actually like to have us look at what that section was when we started it, before all the lobbyists got in here. The banking lobbyists came in and said, well, you can't have the towns doing their own banking laws. That isn't right. So then we put banking in there. And then you had, well, you can't have towns deciding their own environmental laws. I mean, it just got nuts. And I would like to see us go back to those broader and see where we get with that. See if we can. The people, my guess is that the people who voted against it on the floor last year are the same people who are going to vote against it this year, whether it's got 43 prohibitions or 3. They're going to vote against it. So, I mean, and it is so insane the way I can't, I mean, I just was when I was going through our elections through Title VII. Well, a town can have 3 select board members, but if they vote, they could have 5, but they certainly couldn't ever have 4 or 6 or 7, because we know that they're not smart enough to figure out how many select board members they need. Just drives me nuts. Anyway, Senator Clarkson and then Karen. Did you have a question?
I was laughing in appreciation of you.
So Karen.
So, yeah, I think there was a definite evolution in terms of the list of what you can't do. And there, a couple of things sort of strike us this year. There are 2 towns that have proposed charter changes that say that if any provision has been adopted in any municipality, that town, Winooski is one and Williston's the other, that town can adopt it in their community because it's sort of already been proven in another community. And when we first started talking about this whole concept, it was more along those lines, you know, and that would actually also relieve a lot of make work for the legislature. So anyway, that's a different kind of approach.
So can we go back to some kind of language like that, that if we've already approved, the legislature has already approved something in a charter change for one town, then any town, well, that's a whole different thing. That doesn't have to be part of the pilot. That could be any
Right.
town could have that, if we've maybe instead we should have a piece of legislation that says that if we have approved a charter change in any town, that then goes into the general statutes to allow any town to do that with or without a charter. It becomes what do we call it? We have towns with charters that are ruled by charters, and then we have towns that don't have charters that are ruled by the general statutes. So if we've approved it in a charter, then it automatically becomes part of the statutes that any town can. Am I saying that right?
Well, it becomes
Okay.
possible for all towns.
Yeah.
So
Right.
may I read you the language of the charter change proposal from Williston, for instance? It says that any charter change approved for any other municipality may be adopted by majority vote of the electorate as a charter provision in the town of Williston without the need to return to the General Assembly for approval, provided notice is given to the Secretary of State within 30 days of the vote to approve the amendment. So you still have to get it through your electorate.
And that's a little bit different than because what I was thinking here was that it isn't a charter change so
Right.
Putney doesn't have a charter. But if the town of Brattleboro has decided that if we've approved a charter change for Brattleboro to do whatever, to put up a stop sign or to have representative town meeting or whatever, and it becomes part of the general statutes, so that now Putney can do exactly the same thing because it's part of the general statutes. Because if we're approving it for a town with a charter, why would we not just make it general law that any town could do that same thing?
I'm sure there's a good reason.
Sure.
I can think of a couple things though that you get pushback on. Gun laws, elections.
Gun laws and elections.
We haven't yet passed that charter change.
Right.
Yeah, but I think, in other words, if a community, I know Montpelier voted to allow Is it 16-year-olds to vote in local elections?
No,
Brattleboro.
non-citizens.
Non-citizens.
Brattleboro has 16-year-olds.
So if they had gotten that approved as a charter, then Burlington could do that. Is that what you're saying?
Yeah.
What I'm saying is, yes, if
Yeah.
we think it's good enough for Montpelier or good enough for Burlington, why isn't it good enough for Putney and Grafton?
Right. What's good for the goose is good for the gander.
If we don't think it's good for anybody, then we wouldn't approve it in the charter change.
Well,
No.
I'm
Guess I'm just,
not so sure. I think some things are very specific to certain communities.
What would
other
that-
communities may not have that same need.
I
But they
can't
don't
think
need
of
to adopt.
anything. I can't think of anything that if it's good enough for Burlington or good enough for Montpelier, it isn't good enough for Putney.
And they would proactively have to adopt it, but it's there as
Well,
a
yeah.
possibility.
And I think sometimes even within the larger communities, there's a differentiation between like the downtown district and the rest of the municipality. You know, you like, let's say you allowed people to drink openly on Church Street. That would probably be very specific to Church Street, like it is Bourbon Street, but not all of Burlington. So how you might do that somewhere else would be challenging.
But that I don't think is in their charter, isn't it? Those are ordinances.
I don't know. I mean, we let a lot of people do that, right? Like walk away with to-go cups right now.
Well,
but
during the
I don't-
pandemic, we're
Yeah.
letting almost everybody do that.
I don't think that those that Burlington probably has in their charter that they can drink on Church Street. I think my guess is that that's an ordinance, not
Yeah, it
not
sounds
in
like
there.
That's Title VII. Title VII allows outdoor consumption permits for first and third class licensees in designated locations. And Burlington's charter may have something more specific that deals with outside consumption. And Title VII actually does not allow curbside pickup or delivery of alcoholic beverages from first and third class licensees, but it is happening. So
it's happening because of the emergency order.
Yes, but so go back to my contention here. If Burlington, if Title VII allows that, and Burlington has in its, whether it's an ordinance or whatever, that it can happen on Church Street, but it can't happen on Pearl Street. I don't know what. Why wouldn't it be allowed to happen in Putney on Main Street, but not on River Road? I mean, if I cannot think of one single charter change or one single thing that would apply so specifically to one community.
How about cannabis sales? I mean, we're now in the middle of all these towns taking a vote on whether,
Yep.
I mean, to me, that was a mistake in the first place to have an opt-in rather than opt-out. I know Gwen, we will disagree on this, but, then the same would be true for that.
Yes, well, but that's not a charter change. That's not a
Oh, right.
charter. That is, they have the
Right.
right to vote one way or the other, and we're giving them that right. But what I'm saying is that if anything has been approved in any charter for any town, it ought to go into the general statutes to be allowed in any town.
And the town would have to pass it, one assumes. I mean, the town may not want it,
Of course.
but it's available to the town if they so choose.
Yeah. Tucker, I'm sorry. I got this really derailed, but I'm just so.
The different formulations of this are all really interesting, and they all trigger different constitutional analyses under the Vermont Constitution. The first formulation that would allow a chartered municipality to amend unilaterally their charter so long as powers were granted in another municipality's charter might be unconstitutional because they would be amending statute, which is your exclusive power. They can't do that. It would still have to come to you, and allowing them to amend their own charter would be an unconstitutional delegation of your legislative authority. Senator White's proposal is interesting because you are all in the driver's seat for general municipal authority. So if you want to, with any charter that comes up this session, in future sessions, if you see a power that you determine should be a general municipal power, you can add it to the police powers listed in Title 24 in Section 2291, wherever you want to couch it, and you can grant it broadly to any municipality in the state. There's also really interesting constitutional analysis that will have to happen with some of these charter proposals around if powers are granted retrospectively. If the General Assembly says, Williston, you get to have powers that we have already granted as of the effective date of this bill to any other municipality, you've incorporated by reference all of those other statutes into that statute, and that might be constitutional. But then you are not binding future assemblies. So if a future assembly says, City of Montpelier, you specifically get this charter power, it's not entirely clear whether that future power, which is specific and later enacted, would be accessible by a community that has a past authority to adopt any of the powers that have been granted through charter. And you start to get into this area of conflict between, are you actually granting special authority or are you granting general authority? And what is the intent of that future assembly when they pass the statute? And it becomes increasingly problematic for chartered communities. It would ultimately be detrimental to those that have their powers in statute if you had some sort of formula where chartered powers were available to any municipality, because the chartered municipalities would be in a position of, well, we have specific state law that defines our powers. If there's any conflict there, we're going to have to amend our charter, go through the process, and go back to the General Assembly. So there's a lot to unpack there that, at least for me, is really fun and interesting. And I hope it is for all of you too.
Yes, it is very exciting. So
You must be a lot of fun at parties, Tucker.
So, so I guess we should at least try to go back to the pilot project and maybe reduce the change the findings and reduce the number of prohibited areas. And I would actually, I think that it's very interesting that if we saw something coming through in a charter, that we could, I think you're saying, Tucker, is just, and it seemed like something that any town ought to be able to avail itself of. We could just approve that charter, but we could also amend the general statutes to allow that particular thing without this kind of overbroad thing that I was thinking of. And that would be very interesting, because it might, it took us 4 years to allow towns to have their, what was it? Their
town clerks to be appointed. It took more than
yes.
that. Way
Oh my
more
God.
than that.
No, that one.
Parking meter money, parking
meter money. Oh my God.
Parking meter.
So anyway,
that's right.
Maybe we can do, these are separate things, but maybe we can do them both as we see charter changes coming that we want to actually change the general statute. Senator Collimer.
Thank you, Madam Chair. So as you were talking, I had fun. I went back to look at the roll call vote on S106 last year. It was 21-8. And it's really interesting if you look at who voted no.
Yeah.
To me, no discernible pattern.
So who voted no?
because we're on YouTube. Of course, it's all public records. Who cares?
Yeah.
So, for instance, Senator Baruth voted no. Senator Brock voted no. Senator Hardy voted no. Senator McDonald voted no. Senator McNeil of Rutland voted no. So it was kind of like all over the place, and but it did pass. So I don't know that we want to change too much of it. You know what I mean? In other words, not that we have an absolute certainty that we can get it done twice, but I think we can.
I think you're right. I think you're right. I'll keep my idea for another day. I still want to pursue it, but
well, we will have
but
this
I would
opportunity after crossover, because we'll have some charter changes
Yeah.
and we can decide if we want to adopt them for everyone else.
I would like us to look at the are we running over our time here? No.
The next event's at 3:30.
Okay. I would like us to look at the original, what was originally in our bill around the parameters, and then where we ended up.
Tucker has sent that to us, by the way, by email.
Okay.
But before we leave, I know we're going to revisit this list, but I think we should be clear about what is specifically a state power, like revenue, like setting revenue and stuff. I mean, those are specific to we would not be able to, I don't think, grant a more liberal view on those. Like, you're not going to allow, I can't imagine we would allow a toll booth in Rutland.
Well, that doesn't affect just within their boundaries. That would affect people coming in from another municipality, and that isn't allowed.
Oh, right, of course. Okay. Well, but every town is not an island on their own. I mean, every town has people visiting it, and whatever is in that town affects anybody who comes to it.
But yes, of course. But if you, and a stop sign on a town road is going to affect people that are driving through, but it is within their municipality, and it is designed to impact their locality, their municipality.
Right.
I mean, we have state laws. We have state laws that are different than New York and New Hampshire, but and people from New York come here and
the other thing I wondered about is, with the extensive list of what you can't do, what's the point of having the 12-member commission? They don't have anything to do because everything's prohibited anyway. So let's not bother meeting.
Except revenue. Yeah. Right.
No,
yeah, we got to give them something to do.
Yeah, I would like us to look at these and to see why they really are. If it says you can't do anything against the US Constitution, the Vermont Constitution, or state law, that already covers these things. If there's a state law that says that you can dump your raw sewage into the Connecticut River, that's a state law. Putney isn't going to be able to say we're going to dump our sewage in the river. Gwen?
Thank you for bringing that up, Chairwoman. I think that is getting lost in a lot of this. So I think our proposal would be just get rid of that enumerated list and really message it a little bit differently than we did 2 years ago when it was going through the chamber, and saying, we're essentially creating a charter process with actually more review. So it's actually more onerous to go through this process than the charter process. And you're already going to have eyes on it. And I think that already, even when my towns and cities contact, our, VLCT about charter changes, it's almost like their first step is like, what will the legislature approve? Once they figure out where the temperature is, or the barometer, or however you want to qualify it, that's where they start the conversation. So I don't see any community going through this heavy lift of putting all of this together as a community and putting ideas out there that they know instinctively are going to get shot down. So I think that you have to trust the process, not only for what you're reserving as your right as a General Assembly, but and obviously the Constitution was automatically there as a stopgate, but also trusting that the communities are going to be smart enough to understand that if they're going to ask for crazy things, they're going to get shot down, and there won't be a recommendation from the commission to the legislature to say, hey, this is a good idea. And so I think that needs to be the bigger message, rather than this Christmas tree of ornaments that you're hanging, that you're never going to cover everything. And by the time you get to the end, they'll have nothing left.
Karen?
Yeah, just following up on that, another sort of fallback conversation that we had over the last year was maybe just setting up the Self-Governance Commission and letting those conversations happen outside of the State House. And so towns would have that conversation with the Self-Governance Commission. And then if anything came of it, the commission would, come to the legislature or the town would come to the legislature with the backing of the commission, right? There would be somebody that was sort of apolitical, local, state, apolitical, that could support them in whatever the proposal was.
So before we wrap this up today, what I think we should do is look at kind of two options here. One is to go back to the original under 5805, I think it is, C, and the original language there. And the second is to Karen's suggestion, which I think what you were saying was to just set up the commission and don't address these issues at all right now. Let the commission work with the towns around that.
Yeah, around what they think would be appropriate local measures. And just start the conversation, basically.
Right. Without setting up pilots, you mean, and let the commission come back to us and say, you know what, we think it would be great to have pilots because we have this need. These are some of the needs that have cropped up and we'd love to have a pilot.
Right. Or have the town come back to you and say, we'd really like to put these measures in place. And the commission, which has reviewed them, thinks this might be a good idea. But the decision is all still yours. It might just take the conversation out of what in the House seems to be a kind of toxic environment.
I know.
Well, but the composition of the House is so radically changed. I mean, if you look at that GovOps committee, it's a pretty different crowd.
And I wouldn't necessarily think that translated into more support for this idea. I don't know that for a fact, but because if you look at, like Brian just said, if you look at who voted against this, it was
inexplicable.
Mm-hmm.
I mean, at least on face value, right?
So anyway, so let's talk about those two options next week and have some of the rewrites of the findings, take out the toxic ones and just have
well, flip it,
because
make it more positive.
Yeah, that is exactly what the two that Brian was referring to are what generated a ton of conversation on the floor last year, as I remember it. Okay.
On that last piece, could I ask you all to send some of your proposals for the findings and intent, since they are your findings, which is my typical ask of all of you, is to frame them as you have found the issue and express your intent, and I'll put it in for you.
Will do. I can take a stab at writing some of those and sending them to the committee, and then we can get committee input.
I think that is what Brian and I had in mind. Yeah, intent and positive.
Great. Thank you.
Thank you very much.
Madam Chair, speaking of sitting on one's tuchus.
Okay, yes, but before Karen and Gwen go, I just want to remind you of what the Constitution says about this. It says no charter and corporation shall be granted except for each municipal, charitable, educational, penal, or reformatory corporations as are to be and remain under the patronage or control of the state. That old Ethan Allen, he didn't like those towns.
And how that's been interpreted ever since has been very interesting. So.
Yes,
it has.
Especially as it applies to schools and education and towns and cities, for example.
We are definitely not a live free or die state. Manage free or you're definitely not.
Yes, we can have a 5-minute break.
Great. Thank you.
Okay. So I think we had 3 kind of remaining issues. We had Damien posted the bill that I had introduced last year. And I think the 3 kind of remaining issues around temps were the use of temps in the judiciary, which Pat Gable is going to address, who the 800 temps are that didn't go over that 1280. We had an accounting of those who went over the 1280. And then the issue of benefits for temps and what that means. So I think the committee, am I right here in thinking that those were the kind of outstanding issues for us around temps? Brian? Okay. All right, great.
Madam Chair?
Yes.
The only other issue in that bill that was left unaddressed was the issue of temps who have worked, or the proposal that temps who have worked 1,280 hours in 2 or more years be converted over to classified employees so they can be part of the union. That was also in that bill.
It was in that bill. I didn't know if we needed to address it or not, since we heard about a detailed explanation of everybody that did go over 1280 and why they did it. And it seemed there was probably one person that would have fallen into that category. But we can address that if we want to.
I just wanted to make sure that I noted that.
Yep. So. Thank you. Yep. Yes, Senator Clarkson.
And at some point, I would just love a reminder of what temps get, what benefits temps get when. And I know we've addressed a little bit, but to me, that's also a piece of all this.
Right. That was the third issue on my list, was the benefits. So with that, I think I know that Patricia Gable has some time constraints here. So I think we'll go to you first and talk about the use of temps in the judiciary.
Yeah, thank you, Madam Chair, and good afternoon, committee. I'm Patricia Gable. I'm the Vermont State Court Administrator. I'm very aware that you have a very short, even after I finish testifying, you have a very short period of time to cover a number of issues. So I'll try and be as organized as I can. And I believe what I'll try and do is supplement my testimony with a written memo to the committee so that we can keep it brief for now. And so in my bullet points to address, I'd like to talk about the current guidelines that the judiciary uses for temporary employees, how those changed as a result of a VLRB decision, so you can understand how we're guided. The second is to specifically address security personnel, particularly in the Costello Courthouse, and why we've continued to need to use temporary employees there. The third is the committee had asked, if you were going to be fully staffed, well, what would that take? And I can address that briefly, but as I said, I'll follow that up with a memo. And so the judiciary has its own bargaining law, and we have a collective bargaining agreement. And so we've always followed the collective bargaining agreement regarding temporary employees. However, the legislature in the last couple of years, this committee being one of the committees, has made it clear that they're interested as a matter of public policy in reducing the number of temporary employees who are working in a way that appears to be supplementing what should be permanent positions in government. And so as a result of that message that we've received, even though it's not a law, as you know, we substantially reduced the number of temporary hourly employees that we used from 2019 and 8 to 3 in 2020. And we've given you charts on that indicate the reasons why we needed those temporary employees. Nonetheless, we, as you know from our conversation last time, when we asked the legislature for permanent positions for functions that are required to be done in order to keep a courthouse open, for example, and the legislature doesn't appropriate the funds, then we have to find other ways to fulfill our constitutional mandate and to fulfill the various legal requirements expected of the judiciary. And so over the last 5 years, we've consistently requested additional security positions. Early on, we requested somewhere between 15 and 20 positions as a result of a recommendation that we received regarding how many we needed. Most recently, when that got nowhere, we went back and said, okay, well, let's try a few a year. And with the exception of, I think it was in the BAA last year, where we thought we had finally gotten some base funding for 2 positions, as a result of the way the budget ended up being evolved because of the pandemic, we actually lost those 2 positions. And so we continue not to have any additional security positions. And so we do continue to rely on temporary employees. We had a decision from the VLRB, which I will not try to explain to you. Greg Mosley, who's our Chief of Finance Administration, can explain it later if it's necessary. Essentially, even though we don't have any funding for permanent positions or limited service positions beyond what we got in the CARES Act funding, which we are using, the VLRB decided that if we had temporaries working in the judiciary for more than 2 years, that they should become limited service employees, which provides them certain benefits in the judiciary, although limited service employees are still only supposed to be used when there's funding that's dedicated to their employment. As a result of that decision, VSEA and the judiciary are now trying to work through the complications of that, because some of those limited service employees did not want to be permanent employees in the judiciary, did not want the benefits because they were already state government retirees. And so that's something we're working through as a part of that proceeding, but we are trying to manage now under 3 different standards. One standard is what we've always done, which is use temporary employees for backstopping temporary needs. Second is trying to honor the message we've received from the legislature regarding the number of hours you would like to see temporary employees not exceed in a year. And the third is the VLRB decision asking that they not, or directing that they cannot remain as temporary employees if they're employed more than 2 years. And again, if I've gotten that technically wrong, Greg will correct me on that. In response,
excuse
yes.
wait 1 second. Senator Clarkson, did you?
Yeah, your internet got a little wobbly on point number 2. So I hate to ask, but could you repeat number 2 after backstopping your temp needs and the VLRB decision? What was number 2?
Your use of temp employees.
So I thought that was, so it's the other one was what we've heard from the legislature. And what we've heard from the legislature is that you would prefer that temporary employees not exceed 1280 hours. And so what we've been trying to do is manage the use of temporary employees in that context as well, because we're trying to respond to the public policy issues that I assume are behind your requests. I did look at what would it take, how many permanent employees would we need if we were to not only meet our current evolving needs because of the way we're transforming in technology, but also in particular address the extraordinary challenges created by the pandemic. And so we're expecting that the pandemic is going to have an aftermath of more than 2 years, that there are going to be multi-years affecting the justice system. And that isn't just the court system, but all the players in the court system that will be impacted by the pandemic. And so I think, as most of your committee members already know, one thing we did that was helpful is that we dramatically escalated the adoption of technology in the judiciary in order to enable remote proceedings, both on behalf of judges and court staff, and also on behalf of litigants and attorneys and other professionals who appear in the courts. And so because of that, we've been able to remain open as a court system. On the other hand, I think all the legislative committees understand that conducting proceedings remotely in this way does not move proceedings along in the same way you can do as you can do it in person. And therefore, we also have that experience, and we also have what's most concerning to us, that after almost a year, we still haven't been able to hold a jury trial, although we're working very hard on that. All that to say, and I can try and back it up a little bit in writing for you, that if you were to urge your colleagues on the appropriations committees to give us the permanent positions that we would need so that we would not need to turn to temporary employees, we're looking at something like 25 additional permanent positions in the judiciary. And that's a combination of positions that provide support not only to people working in the judiciary, but also to lawyers and self-represented litigants in ways that enable them to continue to interact with the judiciary with the new technology. And also, especially for, I call them unrepresented litigants, most call them self-represented litigants, that more and more our court system is operated in a way that they can navigate it in the ways that they need if either they're unable to obtain counsel or they, for whatever reason, choose not to have counsel. And I think everyone on the committee knows that with the exception of the criminal division, most people interacting with the judiciary are not represented by counsel. And so in addition to those roughly 25 positions, there's another caveat, which is there's expungement legislation that we have some already, and there is additional expungement legislation proposed this year. And based on the current way that we're able to do expungements, even after the technology transformation in the judiciary, if that method is not changed, we'll need an additional 13 positions over and above that, which again is over $1 million. Judge Grierson and Terry Scott, our Chief of Trial Court Operations, are trying to work with subject matter committees and with the other justice partners, some of whom have similar kinds of impacts, to find a way to meet the policy needs for allowing people to move on with their lives, be able to get jobs and rent housing and get mortgages and the like, but do it in a way that doesn't have such a serious impact on the justice system. And so that's another pressure that we face. And we also have some one-time needs for using retired judges and temporary court staff, but those are one-time needs, and we do have one-time funding that comes about as a result of the crazy, ways we've had to budget and the like during the pandemic. And so I don't present those one-time needs because we believe right now that we'll be able to manage those. So I'd be happy to cover more, but I think that's the high points. And as I said, Greg's certainly there to, answer more of the technical questions.
Does any committee, Senator Collmore?
Thank you, Madam Chair. So Pat, I'm just jotting down the numbers here. 25 additional positions. Are those FTEs?
Yes. Full-time.
And the 13 are as well?
Yes.
So if I did my math right, we're looking at about $3.8 million total.
That's right. If the way we do expungement doesn't change, that's about right. Obviously, if we could find a different way to handle expungement and sealing such that we would not need, it wouldn't be so human intensive, that expungement number would be quite a bit different.
Thank you.
Senator Clarkson?
And Pat, of the 25 full-time employees, how many of those are the security needs?
Those are above the security needs. So we currently have, and one of the things I'll do is I will send you our budget submission for this year. So in addition to documenting what those are, I'll send you our budget submission this year so you can see what we're requesting, because we continue to request the funding for the security officers. We're also requesting the funding to support the limited service positions created by the VLRB decision. And back in September, the Judiciary undertook a hit of $500,000 to its base budget as a way to make the contribution that everyone was supposed to be making to the uncertainty of budgeting for FY22. We're requesting that base budget be returned to us because we need it. And one thing that I would mention is we do have one-time funding. We will have carry forward this year. And what we propose is that the carry forward be used to help bring back our base funding. In other words, if we have this short-term need to find monies in places, one-time monies are very different from base funding. For permanent positions, I can't hire a single permanent position without the legislature giving me a position and giving me the base funding for it. And that's why the VLRB decision was somewhat surprising and a little disturbing, because they created basically rights of employees without it being necessarily identified where the money would come from. So, and so we really look forward to working with the legislature and especially the government operations committees, because you're the ones who understand best how government works. We've been very innovative in the judiciary, although, VSEA might describe it in a different way. We found all kinds of ways of trying to meet our needs and move cases along. But the best way to do it is to have an appropriately resourced judicial branch.
Thank you. I do have to say, and I apologize, Pat, for not getting back to you again about the security issue, because I have been talking with some people and there are some suggestions about how it's still going to increase your budget, but how to solve that particular issue, but that doesn't. So, all right, committee, are there any other questions here about the use of because what we're talking about here is the use of temporary positions. And actually, I will say that at 6:30 tonight, VSEA is doing a thing on the general kind of underfunding. and lack of or the hiring freeze and underfunding of positions kind of across the board, and how that impacts services and temps and overtime and everything. So if anybody is interested in attending that, there is a link on our website. So Senator Clarkson?
Yeah, is that sort of like the VSEA dinners that we're not having?
Yes.
When did we get invited to that? I seem to have missed that altogether.
I sent an email out earlier, late morning, early afternoon.
Yeah.
Oh, just today?
Yes.
Yes.
Oh, thank goodness. Okay,
Yeah.
right.
So anyway, I just say that this is an issue across this state. It isn't just in judiciary, but because judiciary is kind of a separate branch, we have to deal with it in a little bit different manner. But
And I would say, Madam Chair, that sometimes there's this very rough approach where some people will say, well, we'll starve the beast. They say they need X and we're going to give them Y and let them figure it out. And, maybe in other times, I've never thought that was a great way to budget. And maybe in other times it was viable. In this time of what the pandemic has done to our ability to meet minimum needs, we really do need a partnership to look much more carefully at constitutional and programmatic issues and look at budget issues from that point of view. And the idea of just, automatic cuts or, not funding roll up of the Pay Act and all of that, those things just eat away at the ability of people to do their work. It's very demoralizing.
Well, and the requirement of us to provide access to justice. I mean, we have a requirement to do this, unlike many other areas of state government. So.
okay, any other questions for Pat? We probably won't be able to solve your issue today.
Where's your wand? Where's your wand, Madam Chair?
In the State House.
I know, we need your wand for Pat.
Maybe I'll ask Bloomer to send it to me. He sent me the rules of the Senate today. Okay, any other questions, committee, for Pat before I know she has to leave us? And I will say this whole, anyway, we also we'll be talking to Senator Sears, because Judiciary is also looking at the budget for Judiciary.
Right. Right. And so as just before you leave, Pat, if you'd be kind enough to remind us the number of temps you currently have to use as a result of everything you sort of painted the picture of. How many temps are you now using in Judiciary?
So it depends on how you categorize them. So we carry assistant judges as temps because they're employees of the county. We have retired judges, we have retired managers, so you leave all of that out. And so the reports that we're giving you are reports over the 1280.
Right.
And so I think if you look at people who don't go over the 1280, and Greg, again, will have the more accurate information, but maybe there might be 6 or 7, something like that. And we're carefully managing to make sure that we're using temporary employees in an appropriate way. For example, we need more docket clerks than we have as we do the transition for Odyssey, the case management system. So we really need them. We need fewer temporary security officers right now because the foot traffic's down. And so we're trying to manage within that. As soon as the buildings open up again, we'll need those security officers back. So the permanent need is there, but we're trying to more closely manage the use of temporary employees.
Did you say 6 or 7 who do not go over the 1280?
I want to defer to Greg on that because I don't know the answer to that.
Greg's there.
Yeah,
So,
are you there?
Yeah, our report from January, I believe, had 3 temp employees that had gone over the 1280 this past calendar year. And the year before that, I think there were 8.
So right now, right now, what we have a lot of temporary employees doing temporary docket clerk work. And those are, for the most part, they're there because as the courts go on to the Odyssey case management system, what happens is you have to scan paper files in on current cases. And so we need temporary employees to come in and support the courts while we do that. So I should say at the moment, we have a lot of temporary employees who haven't gone over any of those limits. And we'll manage that so that they don't. And just to remind the committee, the other category of employee we have in the judiciary is we have limited service employees who are funded by our CARES Act funding. And so unlike the VLRB created limited service positions where there was no money behind it, all of those positions have money behind it. And so we were permitted to use that money both for limited service and for temporary employees. And that's what we've been doing. So for the most part, those additional positions are not in that count of 25 permanent employees, additional employees that we need, because we see the work that they're doing now as temporary, but some of those 25 positions include what are called operations assistants. These are new employees in the judiciary, and they're brought on by the CARES Act, and they're the people who help provide support for the video remote hearings. They've been a life godsend for the judges and court staff. And so they provide technology support to the committee. So Greg, I might have brushed over some technical issues or misstated something. So is there anything that you could correct at this time?
Nothing to correct. So that was all accurate.
Okay, thank you.
Thank you very much. I think Greg can stay on after I'm gone.
We just, I don't think that we are going to actually get to S43 today, committee. I think that we need to, if we jump too much, it is, so I'm gonna reschedule S43 if that's okay. So Becky, I think that Becky was having a conflict there. So anyway, so I guess we're not going to solve the judiciary issue today. That's true. So when I am looking at this, I'm looking at the when we heard the other day, we got a breakdown of all the people who'd gone over 1280 in the executive branch, and that made sense to me. And I have to say, and if there are only 3 in the judiciary that have gone over 1280, I don't see the issue of the people that go over 1280 as an issue. I mean, I don't see that that's much of an issue. There are very few, and we seem to be not having them go over 1280. What I would think, where I think we need to look at is the people who are under the 1280, who are temps. And I think we heard there are 800 in the executive branch, and there are many in the judiciary branch. And if we're managing those people, those positions in such a way that they don't go over 1280, they maybe still should be permanent positions. And because if I'm working and I get to 1240, so then I go to another job or I am not there anymore, or it's designed so that I only work 1240 hours, and then somebody else comes and works another 1240 in the same position. Is that not an issue that we should address, as opposed to the number of people that go over the 1280? Did that make any sense to anybody at all?
Sort of.
No, I want to ask committee members first.
Yes, I think, instead of looking at the outliers there's like one or two, we should be addressing all those folks that we think, or some of us think, need benefits if they're going to continue to be employed.
Yeah.
Senator Colmar?
Thank you, Madam Chair. As I recall, though, they do get some benefits. We
Right.
took testimony last time so I'd like to see what the difference is between full-time and not full-time in terms of the benefits and how close they mirror each other.
Dan, if you want to just refresh ourselves, Dan sent us the list of benefits. I think it's under Dan's name as a witness. Dan, didn't you send us the benefits that temp employees get?
Yes, we sent you a pretty comprehensive list.
Right. It's the estimate for all temporary employees in 2020 if they received half the classified employee benefits.
I do remember that.
Yeah, and it's you could pull it up under Dan's name if you go to Dan as a witness.
So I think that I'm not even thinking about benefits here when I was saying that. What I was thinking about is if we have 800 temps in the executive branch that have not gone over the 1280,
right?
Why do we have 800 temps working? And are we managing them so that they don't go over the 1280 in a way that doesn't then run afoul of the law? Or are they really temps? Because I think that's the issue for me, is that we've already dealt with those people who go over. And, but we have, and maybe I'm wrong here, but we have 800 in the executive branch, and we just heard from Pat that there were many and some of them really are temps, but some of them aren't. So how are we I don't know how to say this. Are we artificially managing those people so that they don't go over the 1280, so they don't run afoul of the law? That's my question. And if that is the case, then how do we address that? And if they truly are all temps, then that's another issue. But if we're artificially managing them, does that make any sense to anybody?
Yeah, yes, it does. And it's been a little bit answered, because I guess I just like a breakdown of the 800. Maybe we got it and I'm just not remembering it. But a lot of people in that group of 800 are choosing to work very part-time.
No, that isn't. We didn't.
Is that not the case? I thought that was the case.
We didn't hear anything about the 800. We heard there were 841 in the executive branch, and we heard about the 31 who went over the 1280, and some of those purposely did not.
Oh, Dan will have to clarify. I thought that there were people who specifically who were retired, or for whatever reason were choosing to work only temporary hours.
Yeah. But so Dan, can you help us here understand if of the and maybe Amy, who those people are, and leaving aside the 500 and some seasonal people, because that's a different category.
Right. Yes, if I may.
Yes, please.
For the record, Dan Pouliot, Deputy Commissioner of Human Resources. With me today, Madam Chair, are Amy Pope, who you heard from last week, also our classification director, and Harold Schwartz, the one and only Harold Schwartz, who puts together these numbers, and we'll all be testifying. So Senator Clarkson referred to the very high level estimate that we provided you last week, which looked at some numbers of the 810 temporary employees. If we were to provide benefits to all of those people based on an average number of 1,040 work hours, for all of them, and it was a very large number. For benefits alone was about $20 million. Okay.
Right.
And that rightfully was, that was simply an answer to the question, what would it cost to provide benefits to all those folks? Based on the conversation we had last week and the questions that your committee asked and we discussed, and also some very cogent rebuttals from the treasurer, who we admire and respect. We've got some better numbers, which we provided to the committee a little earlier this afternoon. It's a lot more detailed than what we gave you last week and provides a much cleaner picture or a clearer picture of what the costs might be based on a couple of tiers of the types of temps that we are employing.
Did you email that to us, Dan, or did you send it to Gail? How can we see it?
Yes, our executive assistant sent it to Gail about 1:30, 2 o'clock, I think.
It's on the webpage. It's in reflection.
I sent that to committee members through email, and then it's also on our committee page. So
sorry, I don't see it on the committee page. I've been trying to. Anyway, okay, I'll look again.
Okay. Well, while Senator Clarkson is doing that.
Got it. I got it.
Okay. I did want to address the benefits that temps already receive, if I could, for just a second. Should note per statute that temporary employees already accrue sick time once they achieve a certain number of hours, and they can accrue up to 40 hours of sick leave per year. So that's a benefit that all temps get now. And they are also eligible to participate in the state's 457B savings plan, which was just enacted by the VSERS organization. I think it was maybe 2 years ago now, maybe a year and a half, somewhere in that range. I'm sure the treasurer has a better date. And I do want to address the fact that we had a number in last week's presentation for the state's retirement contribution, and the treasurer was correct in saying that our number was high because we were in an effort to be simplify things rather than too complicated. We had lumped together the retirement costs as well as OPEB costs for employees and lump those two numbers together. We've split those out for the presentation we gave you today. And I want to note one other thing. We've had a lot of dialogue with the treasurer's office over the past week with regard to the number of retirees who are working as temps. And I think Ram from the treasurer's office, along with Harold from DHR, have kind of centered in on a number that's they're pretty close on. That's somewhere in the range of 120, 125, maybe 105. But I want to note that if by enacting legislation that increases the cost of temporary employees by providing them benefits, with the exception, of course, of retired employees who work as temps who wouldn't need benefits, we are going to, an unintended consequence of that will be that retirees will be less expensive to hire than people who are just starting on their rungs of employment. And managers doing what they do to be as efficient as they can and effective with tax dollars, given a choice between hiring a retiree for a temp position or a recent college graduate or high school graduate, are going to opt for the less expensive employee, and may have an unintended consequence of us hiring lots of retirees rather than people who may be more in need of a job. That's a little bit of an editorial comment there. But with regard to the numbers, I think the best thing for me to do, if you have those numbers in front of you, the spreadsheet we sent you this afternoon, is I'm going to turn it over to Harold, who has calculated some more granular results of the question, how much would it cost for the tranche of employees who work over 1,040 hours versus those that work less than 1,040 hours in a year, and what those numbers look like, and give you a little better clarity on what what the differences are.
Before we go there, can you just tell me now maybe I'm being a nitpicker here, but if we had 810 temporary employees and about 120 of them are retirees, that leaves about 690 temporary employees. Are we artificially scheduling or managing those employees so that they do not go over that 180? Are they truly temp? Those 700 people, are they truly temporary employees, or are they temporary employees so that we don't have to deal with them making those positions permanent?
I am going to answer that question this way, Madam Chair, because it's not a simple yes/no question, of course, right? I don't have a percentage that I could tell you that are truly just temps that are short-term, one need and come and go, versus those that are more of an ongoing but part-time or temporary need. But there are certainly, I will answer affirmatively that there are certainly cases where departments are hiring temporary employees and will work them up towards the limit of the 1280 and then let them go. That does happen. I don't think that's the majority of the cases by any means, but I know that we do in the branch manage some people that way. I would say that the majority, I'm sure are more of what normal people would consider a temporary job. You start at some point in time to complete a project or to do a fill-in job for a period of time. You come, you go. But there are people that recur, and the data will show that Harold put together. The data will show that in 2019 and 2020, there were several hundred people that worked both those years. Most of them much less than 1,040 hours, but there are 60 of them that worked both years, more than 1,040 both years.
Right. And I mean, I can see that there are temporary jobs that might even be every year you need a temporary employee in that job. But I'm just concerned that we are hopefully not managing those temporary employees so that we don't have to address the actual need for the job. That if even 500 of them were temporary at half time, that might be an additional 80 jobs that we should be filling that we're not filling because we keep hiring temporary employees to fill those work requirements. That's my concern.
Right. And I'm glad you phrased the question that way, Madam Chair, because that helps me answer it in I think a clearer fashion. There are, I don't know of any specifics, and I'm sure it's just a handful, if any, of people who of temporary employees who come in, are hired, work for say half a year, 1,040 hours, and then are let go, and then we hire somebody else to do the same job for the next 1,040 hours. That I don't have any indication that any of the departments are doing that. Right.
Okay.
In other words, making up a full-time job out of two part-time jobs. That's not happening.
Okay. Yes, Senator Clarkson.
Well, I mean, yeah, at a certain point, that just cost, that makes no sense from a cost point of view, because the cost of onboarding people is expensive. I mean, that's the cost of training and getting people up and going is also a cost. Dan did mention that there were some retirees that they, were kind of up against that limit that they were aware of and were maybe, it was sort of hit your concern, I think, Madam Chair, but not, anyway. There are clearly some people in this group that I would think would be hit some of your concerns.
Well, there's a huge difference between part-time and temporary.
Right.
I was a part-time employee for 8 years in my position.
But does this chart clarify the difference, or are they all temporary employees, Dan?
This chart is in the data we were asked to put together, and which we do, is that's temporary employees.
So not people who are considered part-time.
No.
Got it.
Yeah. There is a huge difference there, and we don't want to mix them up necessarily. You can have permanent part-time jobs, or you could have temporary full-time jobs, as far as I'm concerned. But anyway, okay, Harold, does any other committee member have, I do know that I'm going to go to Harold, and then I know that Vince, you had a question or a concern, and we'll hear from you also. Okay. You are muted, Harold. You're still muted.
Okay.
Are you talking? You're still muted. There
I
you
got
go.
it.
Oh,
I got
there
it.
he is.
Sorry about that. Harold Schwartz, Director of HR Operations. I took a closer look at the data. I'm going to look at the spreadsheet as I talk. We've been talking about 800 temporary employees in 2020. Actually, there were 840 temporary employees in 2020. What I did for the purposes of this chart, though, was I took a look at those employees who worked both in 2019 and 2020. And I excluded those who didn't work in both of those years. So the totals do not add up. The 575 temps do not add up to the 840. The remainder of the 265 did not work both of those years. And then what I did was I averaged the hours for each of those people over both of those years. And if an individual's average hours were 1040 or more, 1040 is half of full time. I included them in the 1040 or more hours, and if it was less, I included them in the lower level. So as we work through that, those are the categories. And then what I also did was I had an indicator for retirees. There were actually 145 retirees in the entire 840 temp pool. Ram and I worked through those numbers, so we came to a reconciliation on that. But not all of them were in the group that I mentioned, because some of them didn't work both of 2019 and 2020. So if you look down on column B, lines 13 and 14, and you do the subtraction, there were basically 105 temporary employees who were retirees. So the other thing that I did was I then took this group and I pretended like they were classified employees. What additional benefit costs would there accrue to the state, and what additional benefit costs would they incur to get their benefits? Because some benefits, there's a share that the employee shares. For example, on health insurance, the employee shares 20% of the premium and the state takes the other 80% share. Life insurance, 75-25. Dental insurance, the state pays the whole premium on that one. So if you want some more of the detail on the various benefit considerations, if you look down under the assumptions, that will tell you how I did all that. I used single coverage for health insurance as an estimate in our less expensive health plan, but it's our most popular health plan. And then I also, and you can walk through those assumptions and ask me any questions if you'd like. I also broke out the retirement piece. Currently, the retirement contribution by the state is 21.4% of the value of somebody's pay. That's the state, what the state puts in, but that is split between pension and OPEB, other post-employment benefit. And Beth can explain both the pension and the OPEB much better than I can, but I split those two costs out so you can see what those are. And then I summarize the other benefits, which would be dental, life insurance, the employee assistance program, and the value of accrued leave. For a classified employee in their first year of service, they would get 12 days or 96 hours of accrued sick leave and separately 96 hours of accrued annual leave. So that's a bit more than a temporary employee can accrue at this point. So then I added up the benefits, and you can see that in column G for the various groups. And then moving along to the next set under employee compensation, I put in what the amount that is estimated from my calculations that the employees would be paid. And then this is it. And then I calculated what the cost of their share of the benefits would be. And then I subtracted the two, so you can see that their pay isn't necessarily what their net pay is. And then after that, then they have deductions for, taxes and all that. But benefits do cost them some money. I guess that's the point. They're 20% share on health insurance, some on life insurance, the Social Security FICA piece. Excuse me, just a second. Moving down, I took an average per employee, and you can see all that data down below. And then I summarized that under each of those sets, the total and the average per employee. So the number of temps who work 1040 or more hours on average in calendar 19 and 20 was 60, and 12 of those were retirees. The number working less than 1040 hours was 515, and the difference between 515 and 422 were retirees. That's maybe, I don't know, less than 100. So there's a lot more temps working less than 1040 hours by far than are working over half time. The ones who worked over 1040 hours, those include both the ones who worked over 1280 and the others who worked between 1040 and 1280. I'm trying to think if there's anything else. I did not include the seasonal employees. So the benefits would cost something for any of these groups if you gave benefits to all the employees who work in both years. So in other words, if they were temporary employees in 2 years in a row, the benefit costs would be about $2.5 million. If you gave it only to temps who worked 1040 or more hours 2 years in a row, it would be more like $1 million. I don't know. I'm open to any questions.
So, sorry, Harold, where are those figures?
Where are which figures?
The ones you just mentioned, the 2.5, I can't find that
The
here.
2.5, that's on column G 13, 2.496974.
Yeah, those
Okay,
are
we
the
don't
bulk-
have,
Those are the bulk numbers.
oh, the bolt, okay, great. Okay, thanks.
Yeah.
Oh, okay. Thanks.
So where are we, committee? Committee, where? Oh, Vince, did you want to weigh in first?
Yes, thank you. Just briefly, again, it looks like Judiciary is making an effort to address their use of temp workers. And the fact that the numbers they report are low, I think is actually good news, because it's been the constant vigilance of VSEA and the committee that has brought those numbers within a manageable number. My position would be now's the time to enact the legislation before there's a crisis. So we take care of 2 or 3 now and avoid there being, if we lose sight of this issue and move on to other issues, we come back in 2 or 3 years, there might be 20, 30, 50. There could be numbers where we used to see them 8 or 10 years ago. So if you do the bill now, I think it then by law keeps the pressure on to not let those temp workers, in our judgment, be somewhat exploited by the fact that they're working side by side with classified workers without equal compensation. As far as the chart that Harold has put up, it looks like the line that deals with the individuals who are doing 1040 or more hours, excluding retirees, is probably the most relevant to our discussion. 48 employees with a total cost of 1.07. The issue I think to look at there is most of these temps are younger individuals, the ones that are not the retirees. And in most cases, they pay into the system. They build up the insurance, the health insurance fund, and they don't really pull much out of it. So you're adding a healthy group to the pool, providing benefits in case of an emergency. But on balance, I think they benefit the system into which they're paying as well. That would include the retirement, the health, and whatever other benefits are referenced. So the total cost there is 1.07, but I can't tell what the cost to the state is. It's hard for me to figure that out in the chart that I'm looking at.
This is the cost to the state.
That's,
So
yeah.
Okay, so it's 1077.
What group are you looking at?
Well, it's the chart that was referenced earlier.
Which group are you looking at? Are you looking at
1040 or more hours, excludes retirees? It's the second line.
Okay, so the total benefits cost is $852,982.
Okay.
That's in column G in bold.
Okay.
Line 9.
Got it. Okay. So that's a reasonable number. They're effectively working as full-time employees. And again, for the same arguments, they're generally younger and they pay into the system. They really don't draw out of the system. So it's a consideration. It's a manageable number. It addresses the goal that we had in mind. And I think keeps, if you enact the legislation, we don't have to keep coming back to this every year to look at it and report the untoward results, like the poor guy at the Chittenden courthouse that had almost reached the second year of 1040, and so he was terminated after they spent, you got to spend at least 6 months or a year to train somebody, particularly in some of those judiciary clerk jobs. That's a very tedious, complex, and demanding position. So those are my only 2 cents today. Thank you.
Thanks. Committee members, do you have any questions or comments or Beth, would you like to weigh in? I should say Treasurer Pierce.
Beth is fine, thank you. And I would, and I want to thank Harold and those folks and Dan to going back and taking a look at the numbers and working with our staff. Ron Vermer is our IT person, and I know that he and Harold spent a lot of time on this, so thank you to both of you for that. I do support having benefits for temporary workers. I think that that's very, very important. I would agree with you, Madam Chair, that that a lot of people are working up to that 1040 and then, and having to take some time off or do something with that because of the period of time. In my office, we have one or two people over the years. I think we have one now. Harold might correct me. I'm not sure on our retirement staff, but we're also constrained by the number of hours. We talk about folks having a lifetime of financial well-being. That's kind of our mission in our office, and we think very, whether it's financial literacy, the most recent Green Mountain Retirement Program, which is going to provide retirement benefits or the opportunity for retirement benefits for people that are employed in businesses that have 50 or less employees. So we think that this is consistent with that, and that from my end, I think that we should be providing benefits. I would agree with Vince's comment that, that they're working side by side with people. They should be treated equally. And I remember on February 2nd, Vince used an example of an employee that the executive branch had been 22 years as a temp. And I'm not sure if that was for illustration or what, but that sounds pretty tough for me. And I think that we should take a look at it. They would need to meet certain requirements in terms of years of service, and I think that you've addressed that with the 2 years. For me, there would be some logistical issues in the retirement. We'd have to take a look at how we count hours, how we count the years, and
Beth, you just muted yourself.
Sorry about that. So that I think that there are administrative issues, how many years you worked, how to count those, how to define it. We can figure those out, how we calculate that and convert it to years. Again, I think that those are not insurmountable things from our office. And I think that a retirement benefit is very important. The distinction with OPEB, just to let folks know, OPEB refers to other post-employment benefits, which is anything other than your pension, and that really is healthcare, and that is administered through Human Resources, the benefits, and then we pick up the folks and pay and manage the retirees, but they would get the same benefits that they would receive as employees with our current model. And folks that are hired prior to 7108 get 20% their own and 80% subsidy. Folks that were hired after 7108 have a tiered structure. They have to work. I don't have the tier in front of me, but X number of 10 years perhaps to get 40% subsidy, and so on up to after 25 years, I believe, 80% subsidy. So I'm not sure how we'd handle these folks within that context, but certainly would think that, and I would also see many more logistical problems with healthcare, in terms of, whether it's the forms that you do with the IRS and all those other pieces, Dan. I see there will probably be more logistical issues, but I think that that's something that we should take a look at. My bottom line again is that I think everyone should have retirement services. I would obviously eliminate folks that are already in retirement and receiving them, and I would agree that some people that are working consistently from year to year, they really are permanent employees, and people rely on that. So I would support that. And again, go back to my bottom line is everybody should have an opportunity for retirement services and an opportunity for financial well-being. And I think it's great for the economy, because when those young folks or older folks, I didn't say old, I said older folks, have or mature, although, I'm older and I'm not sure I'm that mature, but they should have, they're economic generators. When they spend money, they buy goods and services, and that helps the economy. And we talk about demographics all the time, and the fact that we have, a population of young folks that do not stay here because of benefits, the issues of housing, and that they look for jobs out of the state, which is very unfortunate. We want them to stay. We want them to be part of the economy. We should provide them adequate benefits to do so. And that is my testimony, and I'll take any questions. Thank you.
Committee, any questions for Beth? I have some logistical questions about how so I start working, and I'm working 20 hours a week, which would end up being the 1040.
Yep.
Do I start getting my benefits immediately? Because you don't know that I'm going to be working 1040 hours in this year. I might only work 80, and then the job is over, or I leave. So when does somebody start accruing, and then does it go backwards so that I start accruing and I start paying in immediately, or when do I start? And do part-time people, with permanent part-time people, do they have the same benefits, and are they prorated?
Okay, so again, I think the only benefit they have right now is sick pay and the ability to be in the deferred comp program. So part-time folks, if we were to, oh, you mean part-time permanent?
I mean part-time permanent.
Okay. I'm going to have to defer to my benefits person who is not in, unless Dan or Harold want to help me out with that. But I don't know how we handle part-time permanent on our payroll system. I'd have to check that out.
Yeah, I can speak to that.
Thank you.
Permanent part-time, they would accrue their accrual of their sick leave and annual leave is prorated by their percentage of their schedule. Like if they're half-time, they accrue at half, but they pay full amount for the health insurance, and they would pay a full amount for the life insurance.
And not retire.
So we would
and let me just finish. Retirement is based on their pay. So if they're working part-time, then the retirement piece is part-time.
So we would be paying, under this scheme, we would be paying more for temporary employees than we're paying for permanent part-time. Why would I want to become a permanent part-time?
That's not true. That's not true.
I thought that we would be paying 80% of their healthcare benefits.
That's correct. So it's 80% of a fixed dollar amount that's not prorated. Okay. So we would be paying more be paying the same amount for the temps as we would pay for the permanent part-times. That's the way I costed it.
Oh, I thought you said that for permanent part-time, they pay for the entire healthcare benefit.
No, they pay their entire portion. It's not. It's not prorated by their hours, is what I meant.
Got it. Okay.
So Senator, there would have to be some decisions about that. As I said earlier in my testimony, healthcare is a little more complicated than retirement. Employees hired after 7108 have a prorated process. As I said, 10 years to get 40% subsidy, and then you move up the scale depending on your years of service. I would think that some possibility, and again, I'm doing this a little bit off the top of my head here, some approach would be to convert those part-time hours to full-time equivalents or years of service, and take a look at it that way for healthcare benefits. I think we'd have to talk a little bit more about that. In the retirement, the same thing. You'd have to be vested, which means 5 years of service. So you would need to have some system of converting hours to years of service. And again, those are not insurmountable. I think we need time to talk about those. But I would tell you that when I had this conversation, folks said, well, don't forget about this and don't forget about that. Again, the issue of how to take those hours and convert them to years of service, and taking a look at how that would interact with the current configuration of benefits. Again, that 80% on one group and tiered on another. And it'll also get to the issue of mandatory versus voluntary. I think we have to have a conversation about that I haven't fully addressed in my own thought process on this. So I think we need to have that conversation. I do believe that folks need to pay for retirement, even if they or contribute to retirement, even if they're not. When you're 22 and you're looking and saying retirement's a long way off. At my age, at 67, retirement is not that far off. Although I do want to point out for the record, I have many more years that I plan to be working for this state. But we have some problems to work out. But I think based on principle, that we should have, benefits for all folks. It helps with the economics of the state. It's a win-win. It's good for the individual. It's good for the economics and prosperity of the state. And it's a matter of fairness and equity.
I would just like to interject. I manage the group that manages the state employee health insurance, so I know a little bit about it.
Yes.
For regular employees, there's a 30-day waiting period after you start work before you can get your health insurance, unless you've come from another group plan. But for temporaries, it would be tricky, as Beth has alluded to, because we don't know how long they're going to work during the year. And then what happens after that for regular employees, if they stop working, they would have the chance to go on COBRA, but COBRA is pretty expensive. So that's going to be a tricky issue.
If I could, Madam Chair, it really is. There's also the issue of when you talk about voluntary adverse selection, you don't do it. And then when something goes wrong, you know what I mean? You would select healthcare. In the state system now, anybody hired before 7108 has to elect healthcare coverage at the time of retirement, and it is the same coverage that they have as an active, so that you can't elect to have it, 4 years down the road, and again, have adverse selection when you would select it when you have a more acute issue, and as a consequence, push up the cost. Although I think that, again, people should have coverage. The same thing with retirement. You want to make sure that you don't end up with examples of adverse selection. So we need to have conversations about this. We need to take a look again at the mechanics of healthcare. Seem to me, and I think Harold would back me up on that, a little more complex. Retirement, it is complex, but we could talk about workarounds, and we need to address the issue of voluntary versus involuntary, and there are a lot of issues. But again, the principle stays the same.
Senator Clarkson.
Madam Chair, it's almost 10:05. I sadly have to leave.
Oh, I had no idea it was so late.
Yeah.
I'm having so much fun.
It's very stimulating. And you've given us such good food for thought. This is great. And I'm really enjoying this conversation, but I have to depart. I apologize.
Thank you. I have to leave in a couple minutes also. I had no idea it was so late, but I think that while I appreciate, Vince, your position here on passing this before it becomes a crisis again, I think that we have 2 years of this biennium, and my guess is that it won't be, that we would be under a great deal of criticism if we passed a bill right now that that addressed the I'm not talking about the benefits here, but that address the 1280 issue, since there are so few people who fall into that category, and that could grow again, and that this administration has clearly done a good job of getting that down, and that could grow again, and we don't want it to get there. But I just think that given the time we have, which is 2 weeks before crossover, and the issues that we have in front of us, I'm not sure that this is an issue that we have to pass before March 12th. That's just my take on it, and any other committee member weigh in if you on that. Or not.
I tend to agree with you, Madam Chair. The other piece of this is that, we are going to have, I think, a substantial amount of one-time money, but I don't see any of that being able to be used here. And regardless of what we do, when you look at the judiciary's need of $3.8, $4 million, or close to $1 million to affect the benefit change here, that's going to have to come from the general fund somewhere. And I'm not sure where that's going to come from.
Senator Polina?
Well, I could see agreeing not to do it before crossover, but I would want to make sure that we're not going to drop the issue completely.
Yeah, I didn't mean that we would drop the
Sure.
issue. I just meant that I think that there are issues in here, and my goal would be to get rid of what are not truly temporary employees, to get rid of those positions, and if they need to be, make them permanent positions and address that. Like with judiciary here, we could give their temporary employees benefits, but does it make more sense to put that amount of money into creating those permanent positions that they
Sure.
need? So I think it's more complicated than just passing this bill that we had last year.
Is there
And I
any,
didn't mean to
is there any
indicate that I
interest in,
would-
sorry.
Go ahead.
Wait, Brian, Senator Collmore.
Yeah, I just wanted to make clear, especially to Vince, I didn't mean that I was against doing this either, but I don't think we need to do it in the next 10 days.
Right. Is there any interest in doing part one and then so that the House can start thinking about part one, which would be the automatic conversion after 2 years working full time, and then leave the retirement piece, which is probably where the money is and a little more complicated until later?
I mean, they can start working on it. We could pass it in May, and they could or April, and they could still work on it. But I don't know that. I think that is one of the other piece is very complicated. You're right, but that is the piece that I think we would be under some criticism because for spending time on it, because it isn't an issue right now. The 1240, there were only what we heard from Judiciary was, I think that there were 3 people that fell into that category. And in the executive branch, there were 31, and we had an explanation for all of the 31. So we would be spending time on an issue and passing a bill that isn't an issue right now. Does that make any sense? Did I say that right?
Right, I understand, but it's an issue for the 2 or 3 or the 31. I mean, it's an issue for them.
That we heard, Vince, we had an explanation of every one of the 31 of why they went over. So I'm not sure how we would, 20 of them were for COVID purposes.
Right.
That isn't likely to happen again. And some of them were people who were retired and didn't want to work more than that. So what do you think, committee? Senator Rahm, do you have any thoughts on this?
Well, I just wanted to say I found it really helpful to hear from the judiciary, as we might think of kind of one division or agency, and they're all fairly unique in how this affects them and what it means for turnover and their ability to do their work. So I'd just like to hear more, because I think something that's this massive and affects so many different agencies and departments will incentivize or disincentivize things differently depending on the kind of job they have and the kind of positions that they're hiring in this way. So I'm really fascinated. I'd like to take more testimony. The chart that we have is really helpful. I wasn't clear. The last thing I'm struggling with is where the 800 person figure came from. Because just from looking at this chart, I just want to know if there's another piece of data that I'm missing.
Well, we were told that that the executive branch, Dan told us that there were 810 temporary employees.
Okay, I couldn't make the math work on the.
Actually, if I can interject, there are 840 temporary employees in 2020, but not all of them. Am I muted?
No, you're fine.
Oh, but not all of them worked both 2019 and 2020. So I only used people that worked both years.
Yeah.
So there were 575 people out of the 840 that worked both years, and then I focused on that. So we're not looking at people. We're not looking at people in the analysis I did. We're not looking at people who didn't work 2 years in a row.
Right. Okay. And we just asked, the 800 number came from people who in this year or in the last report were temporary.
That was in calendar 20.
Calendar
Yes,
20.
one other clarification, right? The total number of temps was 841. 31 of them went over the 1280. So the number that we were starting with was the 810.
Right.
Madam Chair, I heard a number, and I just want to ask Harold that. I don't have the chart in front of me, but I'm going to go find it. Thank you. I thought I heard 850,000, and maybe that's what Senator Rahm is referring to, the cost related to one of the subsets of this, and maybe I misunderstood.
Yes, that is for those who work 1040 or more hours, excluding the 12 retirees. So there's 48 of them, and the total benefits cost was $853,000.
Okay, and I can even see that number pretty clearly in bold. I just can't find the 810 when I do the math. I'm just struggling with.
Line 2
and so we're talking about different groups of people, and so it's really, we can't, we're talking about 841 and then 810, and then the 31 are explained, and then we have so many who we have 48 who. So I think that this is my preference here is, and we can think about this a little more, committee, but my preference here is to, given the fact that we have 10 days left to get things over to the House, is to finish up the other things that we're looking at, including S43, and take this up in more detail after crossover. And it might be 2 weeks after crossover, and we can send it over to the House and they can start working on it. It doesn't mean that it won't happen. It just means that, but we can think more about that and figure out how we're going to do this, committee. Does that make sense to anybody?
Sure.
And I think that there are other, and we want to have the privatization conversation also, and I have to say that were we in the State House, I think we could easily address many of these issues, but it is so hard in this remote world. I think, and everybody else may not be feeling the same, but I'm feeling really, really that it is so hard to talk about meaningful changes. and give it the thoughtfulness that it deserves. And this is a decision that I think requires a lot of thoughtfulness. So
I agree.
Me too.
okay. So Vince, I'll see you at 6:30.
Yes, you're all invited to join us at 6:30. We sent the link. It's about and Beth may want to join us as well. We're hearing from the grapevine that if there are changes made to the retirement system that will cause each individual employee to do their own calculation and figure that they better get out now before the getting gets worse, there may be a fairly significant exodus of experienced senior staff.
Oh,
so we're going to talk about the shortages at DLC, the shortages at AOT. The AOT state workers are getting picked off by municipalities in and outside Vermont. And I think it would be good if you could join just at least for a few minutes, half an hour, 45 minutes.
so I misunderstood. I did not know that this was focused on the retirement issue. I
No,
thought
it's
this
not.
was focused.
It's not. It's just that
Okay.
I've heard through. I just brought it up just because Beth's on the phone on Zoom, but these are all issues swirling around the heads of these longtime workers, and a lot of them are being forced to work mandatory overtime, and
Yeah.
they're under a lot of pressure.
So
Yeah, that's what
Madam
I
Chair-
understood, was that it was just talking about the hiring freeze, the shortage of workers, the empty positions, the
Right.
inability to fill positions. So that's okay.
Right.
So,
And
Madam
I'll
Chair,
send-
if I could just do one thing on that, stretch your patience for one more minute, which
It
is I won't be able to-
literally has to be, because in 30 seconds I have to be in another
Sure.
meeting.
We have said repeatedly that we would expect, we're not advocating, nor would I see a situation where the legislature would say it's effective immediately and you do not have time
Yeah.
to make your choices. That's not the way that anyone would operate. We want to give people time. I explained this at the retirement board meeting, and I said this in legislative sessions. There would not be, you have it today, and all of a sudden you got to do something. People will have time to work their decisions, and we will be available to help that.
Yeah, no, I think that's been made clear, but there are shortages of staff in every department and every agency right now that are affecting services provided to Vermonters, affecting overtime, affecting temporary workers and budgets. So
Totally agree.
okay, thank you, committee.